You want to cry in my courtroom? Go ahead. Cry. But every tear costs you 60 seconds, and you are already out of time. The gavel cracks once, not to restore order, but to punctuate the threat. The man standing at the defendant's podium does not wipe his eyes, does not look away. His hands rest flat on the wooden rail, steady as surgical instruments, while moisture tracks down both cheeks in silence. He is 44 years old, wearing a corduroy jacket with a frayed collar and khaki pants creased in the wrong places. His shoes are clean, but old. Nothing about him suggests he belongs anywhere except exactly where the judge has placed him, at the bottom. The judge leaning forward from the elevated bench is Harlan Croft, 62, white-haired, 22 years, on the Franklin County Municipal Court bench in Columbus, Ohio. He presides over housing cases the way a man runs a toll booth, fast, indifferent, and with absolute conviction that every person passing through owes him something. The crying man's name is Marcus Wade. His eviction hearing was scheduled for 9:15 a.m. It is now 9:19. In 4 minutes, Croft has interrupted him 3 times, denied his request to present documentation, and told the courtroom clerk to mark the case uncontested while Marcus was mid-sentence. What Croft does not know, what no one in courtroom 4B knows, is that Marcus Wade has argued cases before the United States Court of Appeals for the Sixth Circuit, that his bar number is registered with the Department of Justice, that every word spoken in this room since 9:15 is being cataloged with the precision of a man who has spent 11 years building federal civil rights cases against exactly this kind of judge. The tears are real. The man they belong to is not who anyone thinks he is. If you have ever watched someone powerful humiliate someone they assumed was powerless, stay here, because what walks through that courtroom door in 47 minutes will be the last thing Judge Harlan Croft ever expects. 4 months earlier, Marcus Wade had driven into Columbus on a Tuesday evening in a 10-year-old Honda Civic with a duffel bag in the trunk and a lease agreement for a 2-bedroom apartment on Bryden Road, East Side, folded in the glove compartment. The apartment was on the 2nd floor of a brick building that had been beautiful in 1952 and was now held together by habit and a landlord's refusal to spend money on anything that did not generate revenue. The lease was real. The apartment was real. The neighborhood, 83% black, median household income $31,000, eviction filing rate 4 times the county average, was real. What was also real, though invisible on any document Marcus carried in his pockets, was the investigation file sitting in a secure server at the Department of Justice, Civil Rights Division, Housing and Civil Enforcement Section, case number DOJ-CR-2024-1187, titled Patterns and Practices, Racial Disparities in Franklin County, Municipal Court Housing Division. 18 months of data collection had preceded Marcus's arrival. Complaint letters from legal aid attorneys, statistical analyses showing black tenants received 40% less hearing time than white tenants in the same courtroom, exposed scheduling patterns where black defendants were clustered into the first 90 minutes of the morning docket, when Croft was hungriest, most impatient, most likely to rule without reading the file. The numbers were damning. But numbers alone did not build federal cases. Prosecutors needed testimony, witnesses, first-person documentation of how the system operated on the ground, in real time, in the body of someone experiencing it. They needed someone to walk into Harlan Croft's courtroom and be treated the way hundreds of black tenants had been treated for years. Marcus had volunteered. His supervisor at DOJ, Section Chief Della Vaughn, had studied him across her desk for a long time before approving the assignment. Della was 57, black, a career litigator who had argued voting rights cases before the Supreme Court and still wore reading glasses on a chain around her neck like a school teacher. "You understand this isn't standard procedure," she had said. "Embedding a trial attorney as a litigant in an active courtroom carries significant ethical and safety considerations." "I understand. You will have no federal identification on your person, no credentials, no backup in the building. If something goes sideways, you are a civilian tenant facing eviction until we say otherwise." "I understand that too. And your aunt, Lorene, She actually lives in that apartment. The eviction action against her is genuine, filed by the property management company 3 weeks ago. If we cannot resolve the underlying case, she loses her home regardless of our investigation." Marcus had not answered immediately. This was the part that made the assignment personal in a way DOJ investigations were not supposed to be. Lorene Wade, 71, had raised him after his mother died when he was 9. She had worked 2 jobs, cafeteria cook at an elementary school and weekend housekeeper at a Holiday Inn on East Main, for 23 years to keep a roof over his head. She had driven him to the public library every Saturday morning until he could drive himself. She had sat in the gallery at his law school graduation with tears streaming down her face and a disposable camera she kept clicking even after the ceremony ended. And now a property management company called Ridgeline Holdings was trying to put her on the street, citing code violations that Marcus suspected were fabricated, filed by a building inspector named Clark Jessup, whose inspection reports appeared in Ridgeline's eviction cases at a rate that defied statistical probability. "The case is personal," Della had said, reading his silence accurately. "That is both the strength and the risk. Your emotional investment makes you a credible witness. It also makes you vulnerable to exactly the kind of judicial abuse we are documenting. Lorene's home is at stake whether I take this assignment or not. At least this way, what happens to her builds a record." Della had removed her glasses, cleaned them, put them back on. 4 months. Document everything. Audio recording is legal in Ohio. One-party consent state under Ohio. Revised Code 2933.52. You record every interaction with court personnel, every hearing, every encounter. You do not reveal your identity under any circumstances until I personally authorize the disclosure. Clear? Clear. And Marcus. She had paused. If that judge makes you angry, and he will, you do not react. You are a tenant. You are confused. You are overwhelmed by a system you do not understand. That is your cover and your protection. The moment you sound like a lawyer, you compromise 18 months of work. He had nodded. He had understood. What he had not understood, what no amount of preparation could have taught him, was how it would feel to stand in a courtroom where the judge looked through him like glass, where the clerk filed his motions in a stack that never seemed to reach the top, where the security deputy watched him the way a dog watches a stranger crossing the yard. He had not understood how quickly a man could be made to feel small. The apartment on Bryden Road smelled like mothballs and cooked greens when Marcus arrived. Lorene had the door open before he reached the second-floor landing, her arms already extended, her body thinner than he remembered from his last visit 8 months ago. "Baby, you did not have to come all this way." "Yes, I did." She held him for a long time in the doorway. The hallway light buzzed overhead, one of its 2 fluorescent tubes dead, the other flickering at a frequency that suggested it would join its partner within the week. The carpet was stained in patterns that told stories no one wanted to hear. 3 of the 5 apartment doors on the floor had notices taped to them. White paper, official seals, the visual language of institutional authority directed at people who had run out of options. Lorene's door had one too. Marcus read it standing in the hallway while his aunt made coffee in a kitchen where the faucet dripped at intervals just irregular enough to prevent the mind from tuning it out. Notice to vacate. Franklin County, Municipal Court. Case number 2, 024-CVG-04471. The tenant is hereby notified that Ridgeline Holdings, LLC, has filed for forcible entry and detainer pursuant to Ohio Revised Code Section 1923.04. The tenant has 28 days from the date of service to respond or appear. The notice was dated 11 days ago. Lorene had 17 days left. Aunt Lorene, when did you get this? Which one? The question stopped him. He turned from the door to face her. She stood in the kitchen holding 2 mismatched mugs, steam rising between her hands, and her expression carried the specific weariness of someone who had been receiving bad news at regular intervals for so long that individual pieces of bad news no longer registered as events. There were others? The inspector came 3 times. First time was in March. Said the bathroom had mold. I showed him the bathroom. It is clean, Marcus. You know I keep a clean home. And he wrote something on his clipboard and left. Second time was April. Said the windows did not meet code. Same windows, been here 31 years, same as me. Third time he brought a camera. Took pictures of the ceiling in the bedroom where the paint is peeling. That paint been peeling since before you graduated high school. She set the mugs on the table. The coffee was instant, made with water heated on the stove because the electric kettle had stopped working and the landlord had not responded to 3 maintenance requests. After the third time, I got a letter from the management company. Said I was in violation of my lease for maintaining unsanitary conditions. Then I got the court paper. Marcus sat at the table. The chair wobbled on its third leg, a problem he had fixed with a folded piece of cardboard in 2019 that was still there, compressed now to the thickness of paper. He looked at the ceiling, the walls, the windows. The apartment was old. It was tired. But it was clean. Lorene had always kept it clean, with a discipline that came from a generation that understood poverty did not have to mean neglect. The inspector, Marcus said carefully. Do you remember his name? Jessup, little man, nervous eyes. Wrote a lot but did not talk much. Clark Jessup. The name matched the file Marcus had studied for 3 weeks before coming to Columbus. Jessup had filed 214 code violation reports in the past 3 years. 187 of those reports targeted properties in majority black census tracts. 143 resulted in eviction filings by the same 3 property management companies. Ridgeline Holdings was the largest. The pattern was not subtle. It was a pipeline. Inspector finds violations. Management company files eviction. Municipal court processes the case on an accelerated docket overseen by Judge Harlan Croft, and black families lose their homes at a rate that would be called ethnic cleansing if it happened in a country Americans felt comfortable criticizing. But calling it what it was required proof, and proof required someone to walk through the system and survive it with documentation intact. I am going to help you fight this, Marcus told his aunt. How? You cannot afford a lawyer any more than I can. He could not tell her the truth, could not explain that he was a lawyer, that he had been a lawyer for 11 years, that he had argued cases in federal courtrooms where the stakes were measured in constitutional precedent rather than monthly rent. Could not tell her that the Department of Justice was watching this case from a secure facility in Washington, D.C., where analysts were tracking every filing, every docket entry, every minute of courtroom audio. I have been reading about tenant rights, he said instead. Ohio law gives you the right to challenge the eviction. You can represent yourself in court. I can help you prepare. Lorene looked at him the way she had always looked at him when he said something that was technically true, but missing essential information. She did not press. She never pressed. She had raised a quiet boy who became a quiet man, and she had learned long ago that quiet people revealed themselves on their own schedule. All right, baby. If you think we can fight it, we fight it. The next morning, Marcus walked to the Franklin County Courthouse at 7:45 a.m. The building was a concrete rectangle on South High Street, architecturally indistinguishable from every other mid-century municipal building, designed to communicate institutional authority through the strategic deployment of right angles and fluorescent lighting. The housing division occupied the 4th floor, accessible by elevator or a stairwell that smelled like disinfectant and resignation. Marcus took the stairs. He counted them. 68 steps from the ground floor to the 4th floor landing. He would climb those stairs 43 times over the next 4 months. Each time, he would count. The 4th floor hallway was already crowded at 7:50 a.m., mostly black faces, mostly women, mostly holding manila folders stuffed with documents they hoped would save their homes, lease agreements, payment receipts, photographs of apartments that contradicted whatever the landlord had claimed. Some held children. Some held nothing at all, having come to court with only their presence and a faith in the system that the system did not deserve. The docket board hung on the wall outside courtroom 4B. Marcus found his aunt's case listed 7th. Hearing time, 9:15 a.m. Judge, Honorable Harlan Croft. He also noticed something the docket board made visible if you knew what to look for. The first 8 cases, all scheduled between 9 a.m. and 10:30, involved black tenants. Cases 9 through 14, scheduled from 10:45 to noon, involved white tenants. The hearing times allocated to the first group averaged 12 minutes. The hearing times allocated to the second group averaged 22 minutes. Marcus photographed the docket board with his phone. The phone's audio recording app was already running, set to continuous capture, time-stamped, uploading in real time to a secure cloud server maintained by DOJ's Digital Forensics Unit. Every sound within range of Marcus's jacket pocket, every whisper, every gavel strike, every judicial aside, was being preserved in a format that would be admissible in federal court. He found a seat on one of the wooden benches outside the courtroom and waited. The bench was hard, the wood worn smooth by decades of anxious sitting. The woman next to him was perhaps 60, black, holding a folder so thick it had been rubber-banded shut. She stared at the courtroom door with the expression of someone waiting for a medical diagnosis. "First time?" she asked without looking at him. "Yes. It goes fast. Do not expect him to listen. Just say your piece and hope for the best." "Does he ever rule for the tenant?" She looked at him then, studied his face, then looked away. "Not that I have seen." At 8:55, the courtroom doors opened. The crowd filed in with the orderly anxiety of people entering a space where their futures would be decided by someone who had not read their files. Marcus took a seat in the third row, left side, where his phone's microphone had the clearest line to the bench. The courtroom was smaller than he expected. Municipal courts did not get the high ceilings and mahogany paneling of federal courthouses. This was a room built for volume, not ceremony. Institutional carpet, dropped ceiling tiles, fluorescent lights that hummed at a frequency just below conscious awareness, but just above comfort. The judge's bench was elevated but modest. The witness stand was a wooden box. The clerk's desk sat to the left, occupied by a woman Marcus would come to know very well. Vera Stanton, 55, white, chief court clerk. She controlled the docket the way an air traffic controller manages landings, with absolute authority and zero tolerance for deviation. Her desk was a fortress of paper stacks, each stack representing a family's housing stability or the lack thereof. She did not look up as the gallery filled. She did not need to. She already knew who was in the room, who was missing, who would win, and who would lose. Her pen moved across a legal pad with the efficiency of someone checking items off a list that had been finalized before the courtroom doors opened. At 9 a.m. exactly, the bailiff announced the court in session. A door behind the bench opened, and Harlan Croft entered the way a man enters a room he has owned for 2 decades, without hurry, without acknowledgement, without any visible awareness that the people standing for him were human beings whose lives depended on the next 90 minutes of his attention. He sat. He adjusted his reading glasses. He opened the first file. Case number 2024-CVG-04208. Ridgeline Holdings versus Tanya Myers. A woman in the second row stood quickly, clutching her folder. She was young, mid-20s, braided hair, a toddler balanced on one hip who seemed confused about why everyone was so tense. "Ms. Myers, you were served with notice of eviction on February 28th. You failed to file a written response within the statutory period. Is that correct?" "Your Honor, I did file a response. I brought it to the clerk's office on March 12th and I show no response in the file." Croft did not look at her. He looked at the file. "Ms. Stanton, is there a response on record?" Vera Stanton checked her pad. "No, Your Honor. No response received." "But I brought it—" Tanya Myers's voice climbed, desperation overriding decorum. "I handed it to the woman at the window. She said she would file it." "Ma'am?" Croft's voice dropped into the register he used when patience was a performance rather than a virtue. "The court cannot accept verbal assertions about filings. If you do not have a time-stamped copy of your response, the court must treat this as uncontested. I have the copy. I have it right here. She opened her folder with one hand, the toddler shifting on her hip, and pulled out a document. See? It has the date, March 12th. Does it have the clerk's stamp? Tanya Myers looked at the paper. Her face changed. The stamp was not there. She had handed the document to someone at the clerk's window. Marcus would later confirm through security footage that the someone was Vera Stanton, and received no stamped copy in return. The document in her hand proved nothing except that she had printed it. Default judgment for the plaintiff. Tenant has 10 days to vacate. Next case. 94 seconds. That was how long Tanya Myers' hearing lasted. 94 seconds to lose the apartment where her daughter had taken her first steps, where the crib was still assembled in the bedroom, where the refrigerator held 3 days' worth of groceries bought with money that would now be needed for a security deposit somewhere else, if somewhere else would accept a tenant with an eviction on her record. Tanya stood in the aisle for a moment, frozen, the toddler sensing something wrong and beginning to whimper. Then she walked out. The courtroom door closed behind her with a sound like a period at the end of a sentence that should have been a question. Marcus watched. He did not intervene. He could not intervene. Intervention meant revealing himself, and revealing himself meant destroying the investigation that might save hundreds of other families from the same 94-second disposal. The cost of that silence sat in his chest like a stone. The next 5 cases followed the same pattern with minor variations: missing filings, denied continuances, interrupted testimony. In one case, a man named Gerald Hoskins asked for a 2-week extension because his wife was in the hospital and he needed time to gather payment records. Croft denied the request without asking which hospital, what condition, or whether the records existed. This court does not grant extensions based on unverified personal circumstances. Default judgment for the plaintiff. Gerald Hoskins left the courtroom, walking in a way that suggested his body was present, but his understanding of what had just happened had not yet arrived. By 9:12, 6 cases had been disposed of. 6 black families. 6 evictions. Average hearing time, 118 seconds. None had been allowed to present documentation. None had been asked whether they had legal representation. None had been informed of their right to appeal under Ohio Revised Code Section 1923.14. Marcus sat in the 3rd row with his hands on his knees and his phone recording everything, and his face showing nothing except the careful blankness of a man who was learning, in real time, the difference between reading about injustice in a case file and watching it happen to human beings 3 feet away. At 9:13, Vera Stanton looked at her list and called the next case number without inflection. Case number 2, 024-CVG-04471. Ridgeline Holdings versus Laureen Wade. Marcus stood. His hands were steady. His voice was not. Your Honor, I am here on behalf of my aunt, Laureen Wade. She was unable to attend due to a medical appointment. I would like to request... Are you an attorney? No, Your Honor. Are you a licensed legal representative? No, Your Honor, but Ohio law permits a family member to provide support at a hearing, not to represent the defendant. If Ms. Wade is not present to speak for herself, this court will treat the matter as uncontested. Your Honor, if I could just present the documentation showing that the code violations cited in the eviction filing are... Mr. Wade. Croft removed his glasses. The gesture was theatrical. A man who wanted the courtroom to see his naked eyes, to understand that the next words would be delivered without the buffer of professional detachment. Your aunt has been cited for 3 separate code violations by the county building inspector. She has failed to file a timely response to the eviction notice. She has failed to appear at her scheduled hearing. The court's patience is not infinite. She is at a doctor's appointment. She has a heart condition. I can provide medical documentation if the court will grant a continuance of... Denied. The word landed like a door slamming. Marcus felt it in his sternum. Not because it was unexpected. He had watched Croft deny 6 continuance requests in the past 13 minutes, but because this time the family being erased from the record was his own. Your Honor, with respect, I am asking for 14 days. 2 weeks. My aunt has lived in that apartment for 31 years. She has never missed a rent payment. The code violations cited in the complaint are documented by a licensed county inspector whose findings this court has no reason to question. Croft leaned forward. Mr. Wade, I have 47 cases on this morning's docket. 47 families whose situations are just as urgent as yours. If I granted every request for extra time, we would be here until Christmas. He paused, looked at Marcus. And what happened next would become Exhibit 14A in a federal civil rights complaint. You want to cry in my courtroom? Go ahead, cry. But every tear costs you 60 seconds, and you are already out of time. The gallery went silent. Not the respectful silence of a courtroom observing decorum, but the stunned silence of people who had just watched a judge say out loud what they had always suspected was happening behind the language of procedure and protocol. 2 women in the back row exchanged a look. The court reporter's fingers paused on her stenotype, hovering above the keys, as though even the machine was reluctant to record what it had just heard. Marcus did not wipe his eyes, did not look away. His tears were genuine. Tears for Laureen, for Tanya Myers, for Gerald Hoskins, for every person who had stood at that podium and been told their crisis was an inconvenience. But his hands remained steady on the rail. His posture did not bend. His breathing stayed controlled. This was the discipline of a man who had been trained to absorb hostility without reacting, not courthouse training. Something else. Something deeper. Your Honor, he said, and his voice was quiet but clear enough for every microphone in the room to capture. I would like this exchange to be preserved in the court transcript. Croft blinked. The request was unusual. Defendants in housing court did not ask for transcript preservation. They cried, they pleaded, they left. They did not make procedural requests with the calm specificity of someone who understood what a transcript was for. Everything said in this courtroom is part of the record, Mr. Wade. That is how courts work. Then I would like to confirm that the court reporter is actively transcribing. May I see a nod from the court reporter? The court reporter, a woman named Dawn Kessler, 38, who had worked in Croft's courtroom for 4 years and had stopped being surprised by anything until this exact moment, looked up. She glanced at Croft. He gave no instruction. She gave Marcus a small nod. Thank you. And I would like to note for the record that my request for a 14-day continuance was denied without the court reviewing the documentation I brought, which includes photographic evidence that the code violations cited in the eviction filing do not exist. Your documentation is not before the court because you are not a party to this action. Your aunt is the defendant. You are a spectator. I am a family member exercising the right under Ohio Civil Rule 75 to assist a party in a housing proceeding. The room shifted. Not physically, no one moved, but the energy changed. Marcus had just cited a specific civil procedure rule, correctly, in the middle of a housing eviction hearing, while crying. Croft noticed. His expression did not change, but his eyes recalculated. The same recalculation Marcus had seen 6 times already that morning, the judge assessing whether the person in front of him knew enough to be dangerous. Civil Rule 75 addresses domestic relations proceedings, Mr. Wade, not housing. Marcus paused. 1 beat, 2 beats. Then, you are right, Your Honor. I apologize. I misspoke. He had not misspoken. Ohio Civil Rule 75 did address domestic relations. Marcus knew this. He had cited the wrong rule deliberately, a calculated error designed to make Croft believe he was dealing with a layperson who had Googled tenant rights the night before and half remembered what he had read. A man who knew enough to be earnest, but not enough to be competent. The misdirection worked. Croft's shoulders relaxed by a fraction. The threat assessment downgraded. This was not a lawyer. This was not a paralegal. This was a nephew with a phone and good intentions and no understanding of how completely outmatched he was. Default judgment for the plaintiff. Tenant has 10 days to vacate. Next case. Marcus sat down. The stone in his chest grew heavier. If this story is already making your blood boil, hit that subscribe button. because what is coming next is going to change everything you think you know about this courtroom. The 10 days began on a Wednesday. Marcus spent the first 3 at the Franklin County Recorder's Office, pulling property records for every building owned by Ridgeline Holdings, LLC. The records were public, accessible to anyone with patience and a willingness to sit in an office that smelled like old carpet and printer toner from 8 a.m. to 4:30 p.m. Marcus had both. Ridgeline Holdings was registered in Delaware, standard practice for companies that wanted corporate privacy at the expense of transparency. The Ohio filing listed a registered agent named Paul Haddix at an address on Broad Street that turned out to be a mailbox store. The company's ownership structure was a set of nesting dolls. Ridgeline Holdings was owned by Parkway Asset Group, which was owned by Marble Creek Capital, LLC, which was registered to a P.O. box in Wilmington. The trail was designed to be difficult to follow, but Marcus had followed harder trails, and what he found at the end of this one, buried in a series of property tax filings that cross-referenced with campaign finance disclosures, was a name he recognized. Commissioner Ray Tillman, Franklin County Board of Commissioners, the man who had appointed Harlan Croft to the municipal bench 22 years ago. Tillman's wife, Sandra Tillman, was listed as the managing member of Marble Creek Capital, LLC, the company that owned the company that owned the company that was evicting Lorene Wade. Marcus photographed every document, uploaded every image, sent a secure message to Della Vaughn in Washington. Connection confirmed. Croft appointed by Tillman. Tillman's family entity controls Ridgeline Holdings. Eviction pipeline benefits Tillman financially. Pattern or practice investigation should expand to include county commission conflicts of interest. Della's response came in 4 minutes. Noted. Continue documenting. Do not confront. Repeat. Do not confront. On the 4th day, Marcus returned to the courthouse to file a motion to vacate the default judgment on Lorene's case. Ohio. Revised Code, Section 1923.081, permitted a tenant to challenge a default judgment within 7 days if the tenant could demonstrate good cause for the original failure to appear. He had drafted the motion on Lorene's kitchen table, writing in longhand on lined paper, because a tenant with no legal training would not produce a typed legal document with proper formatting. The handwriting was careful, legible, and deliberately imperfect. The penmanship of a man trying hard, not the penmanship of a man who had spent 11 years writing federal briefs. The clerk's window on the 4th floor was staffed by Vera Stanton. Marcus approached the window at 8:22 a.m. 2 people were ahead of him in line. He watched Vera process their filings, one accepted with a stamp, one rejected for improper formatting that Marcus could not identify from his position. The rejected filer, a black woman in her 40s, walked away holding her papers with the expression of someone who had been turned away before and expected to be turned away again. When Marcus reached the window, Vera looked at him over her reading glasses. The look lasted approximately 2 seconds longer than professional courtesy required. "Help you? I would like to file a motion to vacate default judgment in case number 2024-CVG-04471. He slid the handwritten motion through the window slot. Vera picked it up, read the first line, set it down. "This needs to be typed. Is there a requirement that motions be typed?" "Court policy. Can you direct me to where that policy is published?" Vera's expression hardened by 1 degree. The shift was subtle. A tightening around the mouth, a fractional narrowing of the eyes. But Marcus cataloged it. He had been cataloged himself in this building so many times that he had become expert at recognizing when others were doing the cataloging. "Sir, I do not have time to explain court policy to every person who walks up to this window. The motion needs to be typed. You can refile when it is in proper format." "I understand, but Ohio Rule of Civil Procedure 11 requires only that a pleading be signed by the party. There is no statewide formatting requirement for pro-SE filings in municipal court. If Franklin County has a local rule requiring typed submissions, I would like to see it so I can comply." The air between them changed. Marcus had done it again, dropped a specific citation that a layperson should not know, then softened it immediately with the earnest deference of someone who genuinely wanted to comply rather than challenge. The balance was essential. Too much knowledge, and his cover was blown. Too little, and his motion would be rejected, and Lorene would lose her home. Vera studied him for a long moment. Behind her, the phone rang. She did not answer it. "I will check with the judge and let you know." "When should I come back?" "When I have an answer." She closed the window partition. Marcus stood in the hallway for a moment, then walked to the wooden bench where he had sat during his first visit. He sat. He took out a small notebook, spiral-bound, the kind sold at dollar stores, and began writing. To anyone passing, he was a man organizing his thoughts. What he was actually doing was recording, in a shorthand he had developed during his years in federal practice, every detail of the interaction. Vera's exact words, her facial expressions, the time-stamp, the name of the woman whose filing had been rejected before him. At 9:40 a.m., a heavy hand landed on his shoulder. "Sir, you cannot sit here." Marcus looked up. The hand belonged to Deputy Trent Bowling, 38, white, courthouse security, whose badge was pinned at an angle that suggested he had dressed in a hurry or did not care about precision. His build was the kind that came from lifting weights without the discipline of stretching afterward, thick through the chest and shoulders, visibly tight in the neck and jaw. His hand did not leave Marcus's shoulder. "The bench is available for public seating," Marcus said. "I am waiting for a response from the clerk's office." "This bench is reserved for people with active cases. Do you have an active case?" "Yes. Case number 2024-CVG-04471. "When is your hearing?" "The hearing was last week. I am here to file a motion." "Then you do not have an active hearing today, and this seating area is for people with scheduled appearances. You will need to wait in the lobby on the first floor." The statement was not true. There was no policy restricting the fourth-floor benches to litigants with same-day hearings. Marcus had read the courthouse's posted regulations on his first visit. They were displayed on a laminated sheet near the elevator, and seating in common areas was available to any member of the public during business hours. But Bowling's hand was still on his shoulder, and the hallway was full of people, black people mostly, who watched the interaction with the resigned familiarity of an audience that had seen this performance before. Marcus stood, slowly, not because he was complying, but because the recording device in his pocket captured audio better when he was upright and facing the speaker. "I will wait on the first floor," he said. "Can I get your name and badge number for my records?" Bowling's hand dropped. "Why do you need that?" "In case the clerk's office calls me back and I need to explain why I am not on the fourth floor." It was a reasonable answer. Bowling knew it was a reasonable answer, but reasonable answers from black men in this courthouse tended to produce unreasonable responses from the people who policed it. "Bowling, badge 419. "Thank you, Deputy Bowling." Marcus walked to the elevator, pressed the button, waited. The elevator was slow, 45 seconds on average, he had timed it. And in those 45 seconds, Bowling watched him with an intensity that had nothing to do with security and everything to do with the particular discomfort some men feel when someone they have diminished responds with politeness instead of submission. The elevator arrived. Marcus stepped inside. The doors closed. He exhaled. 3 floors down, in the first-floor lobby, he found a seat near the window and waited. An hour passed, then 2. At 11:30, he returned to the 4th floor. The bench where he had been sitting was occupied by a white man in a polo shirt reading a newspaper. Deputy Bowling stood 20 feet away, hands clasped behind his back, looking at nothing. Marcus approached the clerk's window again. A different clerk, younger, black, with a nameplate reading D. Hollis, sat behind the glass. "I was here this morning to file a motion to vacate in case 2024-CVG-04471. Ms. Stanton said she would check with the judge about the formatting." D. Hollis checked her computer. "I see a note here. It says handwritten filings are accepted for pro se litigants." "So I can file it?" "You can file it." She accepted the motion through the window slot, stamped it. Marcus watched the stamp land on the first page, confirmation of receipt, date, and time, the small mechanical act that Tanya Myers had never received, and handed back his copy. Your hearing is set for next Wednesday, 9 a.m. Courtroom 4B. Thank you. He had his hearing. Lorene had her chance. What Marcus did not know, because Vera Stanton had not informed the substitute clerk, was that a note had already been placed in the case file. Not a formal notation, nothing that would appear in the electronic docket. A yellow sticky note, handwritten, attached to the inside of the physical folder. It read, Pro C. Difficult. Cited rules. Watch. The following Tuesday, the day before the hearing, Marcus received a phone call at 6:14 a.m. The number was local. The voice was male, professional, slightly nasal. Mr. Wade, this is Clark Jessup, Franklin County Building Inspection Division. I am calling to inform you that a follow-up inspection of the property at 1847 Bryden Road, Unit 2-B, has been scheduled for this morning at 8 a.m. Marcus was standing in Lorene's kitchen. She was still asleep. The coffee was not yet made. A follow-up inspection. Based on what? Based on unresolved code violations identified in previous inspections. This is a routine follow-up, Mr. Wade. Standard procedure. The eviction case citing those violations is currently before the court. A hearing is scheduled for tomorrow. Is it standard procedure to conduct inspections while the underlying case is pending? Silence on the line. 3 seconds. 4. I am not aware of any pending litigation, Mr. Wade. My office schedules inspections independently of court proceedings. The case number is 2024-CVG-04471. You can verify it with the clerk's office. I will note your concern. However, the inspection is already scheduled. A member of my team will be at the property at 8 a.m. Please ensure access is available. The line went dead. Marcus stood in the kitchen holding the phone. The faucet dripped. The fluorescent light in the hallway hummed through the thin apartment door. Outside, a garbage truck groaned its way down Bryden Road with the mechanical indifference of municipal services operating in neighborhoods that existed at the margins of municipal attention. He was being squeezed. The inspection was not routine. It was preparation. New violations found the day before a hearing would give the judge fresh ammunition to deny the motion. Jessup would walk through the apartment with his clipboard and his camera and find problems that did not exist, or inflate problems that did, and by 9 a.m. tomorrow morning the file on Croft's desk would be thicker than it was today. Marcus called Della Vaughn on the secure line. They are sending the inspector today, day before the hearing. Expected. This is the pattern we have documented in 14 other cases. Inspector creates new violations. Management company supplements the eviction filing. Judge cites the updated report. It is a closed loop. Do I let him in? You have no legal obligation to grant access without a warrant or the tenant's consent, but refusing may give the court grounds to draw adverse inferences. Lorene will let him in. She does not know she has the right to refuse. Della was quiet for a moment. Then you educate her, gently, as a nephew would. And if she still lets him in? Then you document everything he does, every room he enters, every photograph he takes, every word he says. And you do the same thing you have been doing for 4 months, Marcus. You watch, you record, you survive. At 7:55 a.m., Marcus woke Lorene, explained, in language that was deliberately simple, that an inspector was coming and that she had the right to be present in every room he entered, the right to ask what he was photographing and why, and the right to request a copy of his report. Lorene listened, nodded, then did what Marcus had feared. She got up, put on her housecoat, and began cleaning an apartment that was already clean. Wiping counters, straightening towels, making sure the bathroom was spotless. Aunt Lorene, the apartment is fine. It is not fine until I say it is fine. Clark Jessup arrived at 8:03 a.m. He was shorter than Marcus expected, 5'7" maybe, with thin wrists and a clipboard that seemed oversized in his hands. He wore a county-issued polo shirt, gray slacks, and shoes that were too clean for a man whose job required entering buildings in various states of disrepair. His eyes moved constantly, scanning the room the way a camera sweeps a landscape. Comprehensive, systematic, missing nothing. "Mr. Wade, Miss Wade, thank you for your cooperation." He produced a business card. Marcus took it, turned it over, noted the county seal and the direct phone number and the email address that ended in @franklincountyohio.gov. Everything appeared legitimate. The man behind the card was the problem, not the card itself. "May I come in?" Lorene stepped aside. Jessup entered the apartment and began his inspection with the focused efficiency of someone following a checklist that existed only in his head. He moved through the living room, photographing the window frames, the baseboards, a hairline crack in the plaster above the front door that had been there since the building was built. He opened closets. He ran his fingers along the top of the refrigerator. He crouched in the bathroom and aimed a flashlight at the grout between tiles, then photographed a dark spot that Marcus could see, from 4 feet away, was a natural variation in the grout color and not mold. "Mr. Jessup, what is that a photograph of?" "Suspected moisture damage." "That is grout." Jessup did not respond. He continued to the bedroom, where he photographed the peeling paint on the ceiling, the same peeling paint that had been peeling for 15 years, and then opened the bedroom window and examined the frame with a device Marcus recognized as a moisture meter. "Elevated readings here, 0.32. "What is the threshold for a code violation?" Jessup paused, looked at his clipboard. 0.25. "And what is the margin of error on that device?" Another pause. Longer this time. Jessup's eyes moved to Marcus's face, and in that moment, Marcus saw the recalculation, the same recalculation he had seen in Croft's eyes, in Bowling's posture, in Vera Stanton's closing of the clerk's window. The assessment. Who is this man, and how does he know to ask questions that tenants in this neighborhood never ask? The device is calibrated quarterly. It is within specification. "May I see the calibration sticker?" Jessup held the moisture meter at an angle that allowed Marcus to see the side panel. There was a sticker, white, with a date. The date was 14 months old. Calibration was supposed to be quarterly, 4 times per year. The device had not been calibrated in over a year. Marcus said nothing. He wrote the date in his notebook. The notebook was visible. Jessup watched him write. The inspection continued for another 22 minutes. Jessup found, or created, 6 new violations: the moisture reading, the suspected mold in the bathroom grout, the peeling ceiling paint, a loose electrical outlet cover in the kitchen, a gap beneath the front door that he described as insufficient weather sealing, and a scratch on the kitchen floor linoleum that he classified as tripping hazard. 6 violations. In a clean apartment maintained by a 71-year-old woman whose greatest domestic failing was a peeling ceiling she could not reach and a scratched floor she could not afford to replace. Jessup left at 8:27 a.m. He did not provide a copy of his report. When Marcus asked for one, Jessup said copies would be available from the county office within 5 business days. The hearing was tomorrow. Marcus closed the door, turned to face his aunt. Lorene stood in her kitchen, hands folded, looking at the front door as though Jessup's ghost still stood in the doorway, with his clipboard and his camera, and his quiet, meticulous dismantling of her right to remain in her own home. "Baby," she said, "that man found things wrong with this apartment that I have lived in for 31 years, and nobody has ever complained about." "I know." "He took pictures of my grout." "I know." "My grout, Marcus." He put his arm around her shoulders. She was smaller than he remembered, thinner. The bones of her back pressed through her housecoat like the framework of something that was being slowly disassembled. "We are going to fight this, Aunt Lorene, tomorrow, in court. And I'm going to make sure that judge hears every single thing you have to say." She nodded, but her eyes stayed on the door. "If you think what has happened so far is unjust, keep watching. Because tomorrow's hearing is going to make today look like a warm-up." That evening, Marcus sat at Lorene's kitchen table with 4 documents spread in front of him. The original eviction notice, the motion to vacate he had filed, a printout of Jessup's inspection history he had obtained from public records, and a handwritten timeline of every interaction he had documented since arriving in Columbus. His phone rang. The caller ID showed a local number he did not recognize. "Mr. Wade, this is Nadine Okafor. I am a staff attorney at the Legal Aid Society of Columbus. I understand you have an eviction hearing tomorrow in Judge Croft's courtroom." Marcus set down his pen. "How did you know about my hearing?" "The court publishes the docket. I review housing cases daily. Your aunt's case caught my attention because the motion to vacate was handwritten, which is, I will be honest, unusual, and because the code violations cited by the inspector follow a pattern I have seen in other Ridgeline Holdings cases." Nadine Okafor. Marcus knew the name. It was in the DOJ file, one of the legal aid attorneys whose complaint letters had triggered the investigation. She had written 3 separate letters to the Ohio Supreme Court's Office of Disciplinary Counsel about Croft's conduct, none of which had produced action. She had been documenting the same patterns Marcus was documenting, but from outside the system, without the resources or authority of the federal government. "I appreciate the call, Ms. Okafor. What can you tell me?" "I can tell you that Judge Croft has ruled against the tenant in 94% of cases heard in his courtroom over the past 3 years. I can tell you that Ridgeline Holdings is the plaintiff in 31% of those cases, and I can tell you that Clark Jessup has filed inspection reports in connection with every single one of those Ridgeline cases. That is a pattern. It is a pipeline. But I cannot prove it, because the pieces are spread across different offices, different databases, different jurisdictions. I am one attorney with 60 active cases and no investigative staff. I can tell you what it looks like. I cannot tell you what it is." "What does it look like?" "It looks like a county judge, a building inspector, and a property management company are operating a coordinated eviction scheme that disproportionately targets black tenants. But I did not say that on a recorded line, and you did not hear me say it." Marcus almost smiled. Almost. "Ms. Okafor, I appreciate your honesty. Can I ask, is there anything specific I should know about tomorrow's hearing?" "Yes. Croft will have the new inspection report. Jessup files digitally with the court. The report goes directly to Croft's clerk, bypassing the normal distribution process. Your aunt's file will be updated before you walk through the door. The new violations will be cited as grounds to deny your motion. Can I object to the report on the grounds that the inspection was conducted the day before the hearing?" "You can try. Croft will deny the objection. He will say the report is a public record and admissible without formal discovery. He will be technically correct under Ohio Evidence Rule 803, which allows public records as an exception to hearsay. But the timing is prejudicial, and you could argue that the late supplement deprives you of adequate time to respond." "Will he care?" Nadine was quiet for a moment. When she spoke again, her voice was different, stripped of the professional distance that attorneys maintained out of necessity and habit. "No, he will not care. But it will be on the record, and records matter, even when the person reading them does not exist yet." After she hung up, Marcus sat at the table for a long time. The kitchen was quiet. Lorene had gone to bed at 8:30, as she did every night, and the apartment settled around him with the creaks and sighs of an old building adjusting to the absence of human movement. He opened his laptop. Not the one he carried to the courthouse, a cheap Chromebook that reinforced his cover, but a second device, secured, encrypted, running on a DOJ network that routed through 3 proxy servers before reaching the open internet. He logged into the case management system and uploaded his recordings from the day, the phone call from Jessup, the inspection audio, the conversation with Nadine Okafor. Then he opened the investigation file and read the section he had been avoiding. Subject: Judge Harlan L. Croft, Franklin County Municipal Court. Appointed 2002 by County Commissioner Raymond Tillman. Retained by voters in 2008, 2014, 2020. No contested elections. Judicial Conduct Board complaints, 7 filed, 0 sustained. Annual caseload, approximately 2,400 housing cases. Average hearing time for black defendants, 3.2 minutes. Average hearing time for white defendants, 8.7 minutes. Default judgment rate for black defendants, 89%. Default judgment rate for white defendants, 41%. The numbers. Every time Marcus read them, they hit the same way. Not as abstractions, as lives, as people. As Tanya Myers and Gerald Hoskins and a woman in the back row whose name he did not know, but whose face he would remember. He closed the laptop, made instant coffee, sat at the table drinking it in the dark, listening to the faucet drip, counting the seconds between drops the way he had counted courthouse stairs, the way he had counted hearing times, the way he counted everything because counting was how he kept himself anchored to reality when reality was trying to dissolve beneath his feet. Tomorrow, he would walk back into courtroom 4B. He would stand at the podium. He would present his motion. And Harlan Croft would deny it, because denying it was what the system required, and what the system rewarded, and what the system had been doing, undisturbed, for 22 years. But tomorrow would also be different, because Marcus was going to do something he had not done in his first appearance, something that would shift the dynamic in ways Croft could not predict or control. He was going to let Laureen speak. Not because Laureen was a compelling witness, though she was. Not because her testimony would change the outcome, it probably would not. But because Laureen's voice, Laureen's story, Laureen's 31 years in an apartment that a man with a clipboard was trying to condemn, would be captured on a recording that federal prosecutors would play in a courtroom where the judge actually listened. And because Marcus Wade, for all his training and discipline and careful construction of a cover identity that required him to appear weak, had reached the limit of what he could watch in silence. The faucet dripped. He counted. 3 seconds between drops. Tomorrow. Wednesday morning broke gray and cold over Columbus, the kind of late November weather that turned the city's concrete architecture into a study in monochrome. Marcus dressed in the same corduroy jacket, the same khaki pants, the same clean old shoes. Laureen wore her good dress, dark blue, long-sleeved, with a small brooch at the collar that had belonged to her sister, Marcus's mother. She had pressed the dress the night before, hanging it on the bathroom door where the steam from the shower would smooth the wrinkles. They arrived at the courthouse at 8:40 a.m. The security checkpoint on the first floor was staffed by a bailiff Marcus had not seen before. Older, black, with the measured movements of someone who had been doing the same job long enough to do it fairly without being told. He processed Marcus and Laureen through the metal detector without commentary, without the theatrical ID examination, without the shoulder touches and pocket checks that Deputy Bowling administered to black visitors with the regularity of a ritual. On the fourth floor, the hallway was already full. Same faces, different cases. The docket board showed Laureen's hearing listed third. 9:15 a.m. Marcus led his aunt to a bench, the same bench from which Bowling had evicted him the previous week. Bowling was not on duty. A younger deputy stood near the courtroom door, checking his phone with the bored posture of someone counting minutes until his shift ended. Marcus. Laureen's hand found his arm. I am scared. I know. That man, the judge, Tanya at church told me about him. She said he does not listen. He will listen today. How do you know? He did not know. What he knew was that the microphone in his pocket was running, that the DOJ server was recording, that somewhere in Washington, Delavon was monitoring the feed with a team of attorneys who had built careers on cases exactly like this one. What he knew was that even if Croft did not listen, the record would exist, and records outlasted judges. Because you are going to tell him the truth, Marcus said. And the truth is hard to ignore when it comes from someone who has lived it for 31 years. Laureen squeezed his arm. She did not look convinced, but she straightened her back, adjusted her brooch, and faced the courtroom door with the posture of a woman who had survived worse than a man in a black robe. At 9 a.m., the doors opened. They filed in. Marcus guided Laureen to the third row, left side. His usual position, close to the podium, within range of the bench microphone. Vera Stanton was at her desk. She looked up when they entered. Her eyes moved from Marcus to Laureen and back to Marcus, and something in her expression tightened. Recognition. calculation, the awareness that the man she had turned away from her window was back, and this time he had brought the defendant. Croft entered at 9:02. Same walk, same indifference, same adjustment of the reading glasses. The first two cases were dispatched in under 4 minutes combined. Both black tenants, both default judgments. Both walked out of the courtroom carrying the particular emptiness of people whose last hope had just been administratively processed into non-existence. Case number 2024-CVG-04471. Ridgeline Holdings versus Laureen Wade. Motion to vacate default judgment. Marcus and Laureen stood. They walked to the podium together. Marcus positioned himself slightly behind and to the left of his aunt, physically present, visually subordinate, occupying the space of a support person rather than a representative. "Ms. Wade," Croft said, "you failed to appear at your original hearing." "Yes, Your Honor. I had a doctor's appointment. My heart—" "Do you have documentation of this appointment?" Laureen opened her folder. Her hands were shaking. She pulled out a letter from her cardiologist, dated, signed, confirming an appointment that conflicted with the hearing time. She handed it to the bailiff, who carried it to the bench. Croft glanced at the letter, set it aside. "The court notes the medical documentation. However, I also note that the county building inspector has filed a supplemental report dated yesterday identifying 6 additional code violations at the subject property." "Your Honor," Marcus said from his position behind Laureen, "the supplemental inspection was conducted less than 24 hours before this hearing. My aunt was not given adequate notice or opportunity to—" "Mr. Wade, you are not a party to this case. I allowed you to be present as a family member. If you wish to speak, you may request permission." "I request permission to speak." "Denied. Ms. Wade, the court has before it the original inspection report identifying 3 violations, the supplemental report identifying 6 additional violations, and your failure to appear at the initial hearing. What do you wish to say?" Laureen looked at Marcus. He gave her a small nod. She turned back to the bench, and she spoke. "Your Honor, I have lived in that apartment for 31 years. I moved in when I was 40 years old, after my sister passed, and I took in her boy. He was 9. I raised him in that apartment. He slept in the bedroom where the man said the paint was peeling. He did his homework at the kitchen table, where the man said the floor was scratched. I have paid my rent every month for 31 years. I have never been late. I have never been complained about. I have never caused a problem for anyone." Her voice was steady now. The shaking in her hands had stopped. There is a quality that some people carry, an authority that has nothing to do with titles or credentials, or the institutional power that Croft wore like a uniform. And Laureen Wade had it. It was the authority of experience, of survival, of a life lived in full awareness of its own fragility and a refusal, despite everything, to be diminished by that awareness. The inspector came 3 times. The first time, he said there was mold in my bathroom. There is no mold. I clean that bathroom every morning. The second time, he said the windows were not up to code. Those windows have been there since before I moved in. Nobody said anything about them for 30 years. The third time, he brought a camera and took pictures of things that have always been the way they are. Paint peeling on the ceiling I cannot reach. A scratch on the floor from when Marcus, my nephew, dropped a pot in 2011. She paused, breathed, continued. Yesterday morning the inspector came again. He found 6 more things wrong. In an apartment I have kept clean for 31 years. 6 new problems that appeared overnight, the day before my court hearing. Croft's expression did not change. His pen moved across the file. Whether he was writing notes or drawing lines through items on a checklist, Marcus could not tell. "Ms. Wade, the court appreciates your testimony. However, the code violations are documented by a licensed inspector. This court does not have the authority to second-guess the findings of a county official acting within his jurisdiction. Your Honor, I am not asking you to second-guess him. I am asking you to look at my apartment. Come see it. See if what he wrote down matches what is there. That is all I am asking." The request hung in the courtroom air. It was not a legal argument. It was not a procedural motion. It was something simpler and, in its simplicity, more powerful. An invitation to verify, to look, to see. Croft did not accept. The court does not conduct site visits in housing matters, Ms. Wade. The inspection report is the court's evidence. Motion to vacate is denied. The original default judgment stands. Tenant has 7 days to vacate. 7 days, not 10. Croft had shortened the original timeline by 3 days without citing any legal basis for the reduction. Your Honor, Marcus said, stepping forward before he could stop himself. Ohio Revised Code 1923.06 requires a minimum of 10 days' notice before execution of an eviction judgment. The court cannot shorten that period without— Mr. Wade, I told you that you do not have permission to speak. One more interruption and I will hold you in contempt. Marcus stopped. The words were in his mouth, the statute number, the case law, the specific appellate decisions that prohibited exactly what Croft had just done, and he swallowed them, every one, because speaking them would end the investigation, would reveal that the man in the frayed corduroy jacket knew more about eviction law than the judge pretending to apply it. He stepped back. Lorene reached for his hand. He took it. Next case. They walked out of the courtroom. Lorene did not cry. She walked with the same posture she had carried in, straight back, brooch at her collar, the quiet dignity of a woman who had just been told her home was no longer hers, and who refused to let that information change the way she moved through the world. In the hallway, Marcus guided her to a bench. She sat. He sat beside her. The hallway traffic moved around them, other families, other hearings, other futures being processed into paperwork. 7 days, Lorene said. We are going to appeal. Can we? Yes. He did not say, and the appeal will be filed not in this courthouse, but in a federal building downtown, and the signature on the complaint will not be mine, but will belong to the United States Department of Justice, and the judge who reads it will not be Harlan Croft, but a federal magistrate with the authority to freeze every eviction proceeding in this courtroom until the investigation is complete. He did not say any of that. He sat with his aunt on a wooden bench in a hallway that smelled like floor wax and disappointment, and he held her hand, and he counted the seconds between her breaths the way he counted everything, because counting was control, and control was the only thing he had left in a building designed to take everything else away. At the far end of the hallway, Vera Stanton emerged from the courtroom carrying a stack of files. She walked past Marcus and Lorene without looking at them. But as she passed, Marcus noticed her right hand, the hand not holding the files, reach into her blazer pocket and remove her phone. She typed something with her thumb, a quick message, eyes forward, the practiced discretion of someone who had learned to communicate without appearing to communicate. Marcus could not see the screen, could not read the message, but he noted the gesture, the timing, the direction of Stanton's gaze as she typed. She had been looking at Marcus and Lorene 3 seconds before reaching for the phone. Someone was being notified. Someone was being told that the man who cited rules and asked questions and brought his aunt to court was still in the building. The question was, who? The answer came 2 hours later, though Marcus did not recognize it as an answer at the time. He was standing in the first-floor lobby, using the public computer terminal near the information desk to access the court's electronic filing system, a process that required a patience level typically reserved for hostage negotiators, because the system ran on software that appeared to have been last updated during the second Bush administration. He was searching for Jessup's supplemental inspection report, which should have been filed electronically and accessible through the public portal. The report was not there. He searched by case number, by date, by inspector name, by property address. Nothing. The supplemental report that Croft had cited in denying Lorene's motion, the report containing 6 new code violations found the day before the hearing, did not appear in the electronic filing system. It existed in the physical file on Croft's desk. It had been read aloud in open court, but it had not been entered into the system where the public could access it, where journalists could find it, where federal investigators could download it. The report was real enough to evict a 71-year-old woman, but it was invisible enough to evade scrutiny. Marcus typed a note on his phone. Supplemental inspection report cited in hearing not filed electronically. Physical copy only. Possible deliberate exclusion from public access. Verify with county IT whether filing was suppressed or never entered. He sent the note to the secure server. Then he logged out of the public terminal and walked toward the building exit. The front doors of the Franklin County Courthouse were heavy glass, framed in aluminum, the kind of doors that required a committed push from someone who meant to leave. Marcus was 3 steps from those doors when a voice stopped him. "Mr. Wade." He turned. Priya Dalton stood in the lobby, briefcase in one hand, the other extended for a handshake that Marcus did not accept because his hands were in his pockets, and removing them felt, in that moment, like a concession. "I am the attorney representing Ridgeline Holdings in your aunt's eviction case. I wanted to introduce myself and discuss a resolution that might work for everyone." Priya Dalton was 41, Indian American, a graduate of Capital University Law School who had built a practice representing property management companies in housing court. She was good at her job, which meant she was good at removing people from their homes using the language of compliance and the mechanics of procedure. Her suit was dark gray. Her heels clicked on the lobby tile with the rhythm of someone who walked with purpose. "A resolution," Marcus repeated. "Your aunt's situation is difficult, and I understand it is emotional. But the code violations are documented. The court has ruled. Continued litigation is only going to delay the inevitable and increase costs for everyone." "What kind of resolution?" "Ridgeline is willing to offer a voluntary relocation package, 2 months of alternative housing assistance, a clean rental reference, waiver of any outstanding maintenance charges. In exchange, your aunt agrees to vacate within 14 days and waives her right to appeal." 14 days. 3 more than the judge had given. Dalton was presenting it as generosity. "And if she does not accept?" Dalton's expression shifted. Not dramatically, not threateningly, but with the calibrated adjustment of someone moving a negotiation from the pleasant phase to the realistic phase. "Then the eviction proceeds under the court's order. 7 days. No relocation assistance. The judgment goes on her record. Finding new housing with an eviction judgment in Franklin County is, I am sure you can appreciate, significantly more difficult." The threat was embedded in the offer like a fishhook in bait. Accept and surrender quietly, or resist and be destroyed publicly. The choice was designed to feel like a choice while functioning as compulsion. "I will discuss it with my aunt." "Of course. Take a day. But the offer expires Friday at 5 p.m. She produced a business card. Marcus took it. "My direct line is on the card. I hope we can resolve this amicably, Mr. Wade." She turned and walked toward the elevator bank, heels clicking in measured intervals that matched, Marcus realized, the cadence of a clock. Counting down, always counting down. He stood in the lobby for a moment after she left. The glass doors reflected his own image back at him. A man in a worn jacket, holding a business card, looking exactly like what everyone in this building believed him to be. Someone out of options. Then he walked out into the gray Columbus afternoon and called Della Vaughn. They offered a relocation package in exchange for dropping the appeal. How much? 2 months housing assistance, clean reference, waiver of appeal rights. That is an unusually generous offer for a routine eviction. Ridgeline does not typically offer relocation packages. They are trying to make this case go away. Because of the questions I have been asking. Because of the questions you have been asking, which means they are paying attention, which means the pressure is working, which also means you are now visible to people who have a financial interest in making you invisible. Watch your back, Marcus. Always. And Marcus, do not accept the offer. But do not reject it yet either. Tell them you need time. Keep the negotiation open. Open negotiations generate documentation. Documentation builds cases. He hung up. Started walking toward Bryden Road. The sidewalk was cracked, the trees bare, the neighborhood wearing November the way it wore every season. with a weary patience that suggested it had been waiting a long time for something to change and had learned not to expect it. 13 blocks later, he turned onto Bryden and saw something that stopped him on the sidewalk. A man was standing on the front steps of Lorraine's building. Not Jessup, someone else. Taller, heavier, wearing a reflective vest over a dark jacket. He held a clipboard and was examining the building's exterior with the focused attention of someone cataloging details for a specific purpose. As Marcus watched, the man took out a phone and photographed the front entrance, the mailboxes, the fire escape, and the address numbers mounted above the door. Marcus approached. "Can I help you?" The man turned. White. Mid-50s. Eyes that assessed Marcus with the quick, dismissive efficiency of someone accustomed to being challenged by people he did not consider significant. A name tag on the vest read, City of Columbus, Code Enforcement. "Just conducting a building assessment. Routine." "Routine for what?" "For the record." The man clicked his pen, made a note on his clipboard, did not elaborate. "Are you with the County Building Inspection Office? Clark Jessup's office?" "I am with the city. Different department." Different department, different jurisdiction. A second layer of inspection from a separate agency, targeting the same building. Marcus had not seen this pattern in the DOJ file. This was new. "Can I see your identification?" The man produced a city ID badge. His name was Dennis Merrick. His title was Senior Code Enforcement Officer. His badge photo matched his face. Everything appeared legitimate, which, in Marcus's experience, made it more suspicious rather than less. "Mr. Merrick, is this assessment related to any eviction proceedings currently filed against tenants in this building?" Merrick's clipboard lowered by 2 inches. His eyes met Marcus's for the first time with genuine attention rather than professional dismissal. "I am not at liberty to discuss the purpose of an active assessment. If you are a resident, you will receive notification of any findings through proper channels." He turned and walked down the steps, climbed into a white city vehicle parked at the curb, drove away without looking back. Marcus stood on the sidewalk, watching the vehicle disappear around the corner on Champion Avenue. The afternoon was fading. The streetlights were beginning to flicker on, the orange sodium vapor kind that turned everything beneath them into a study in amber and shadow. 2 inspection agencies, 2 clipboards, 2 sets of photographs of a building where a 71-year-old woman was fighting to stay in the apartment she had called home for 3 decades. The system was not just coming for Lorraine Wade, it was coordinating. And Marcus Wade, trial attorney, United States Department of Justice, Civil Rights Division, was standing on a cracked sidewalk in a worn corduroy jacket, watching it happen, documenting it, recording it, surviving it. Because that was the job. Because that was the cost. Because somewhere between the principle and the practice of civil rights law, there was a gap where human beings lived and suffered and lost their homes, while the machinery of justice turned at the speed of bureaucracy, and the only way to close that gap was to stand inside it. His phone buzzed. A text from a number he did not recognize. No name. No greeting. Just 6 words. "Stop asking questions about Jessup." Marcus read the message twice, screenshotted it, uploaded it to the secure server. Then he walked inside, climbed the stairs to the 2nd floor, and locked the door behind him. Lorraine was in the kitchen. The faucet dripped. The light hummed. The smell of cooked greens filled the apartment like a memory of stability in a building where stability was being dismantled, one inspection report at a time. "Dinner is almost ready," she said. "Smells good." He sat at the table. The chair wobbled on its cardboard shim. He did not fix it. He sat with the wobble, with the drip, with the hum, with the anonymous text message burning in his phone, like a small fire that would eventually, he had no doubt, spread. 7 days. But Marcus Wade was not counting days anymore. He was counting evidence. And the count was rising. The anonymous text sat in Marcus's phone like a splinter under the skin. Not fatal, not forgettable, just persistent enough to change the way he moved through the next 72 hours. He did not respond to the message. Responding would confirm that the number was active, that the recipient was paying attention, that the pressure had landed somewhere it could do damage. Instead, he forwarded the screenshot to Della Vaughn's secure line and continued his evening routine. Dinner with Lorene, dishes washed by hand because the dishwasher had broken in 2021, quiet conversation about nothing important while the faucet dripped its 3-second metronome. But the message changed the arithmetic of the investigation. Someone knew that Marcus was asking about Clark Jessup. Someone cared enough to warn him off. And warning someone off required knowing who they were, where they lived, and what phone they carried. Information that should not have been accessible to anyone outside the DOJ's secure communications network. Which meant either the warning came from inside the courthouse system, or someone had been watching Marcus carefully enough to connect his questions to his phone number. Neither possibility was comforting. Thursday morning, Della called at 6:45 a.m. "We traced the number, prepaid phone, purchased at a Walmart on Morse Road 3 weeks ago, cash transaction, no surveillance footage available. The store recycles camera data after 14 days. Dead end. Not entirely. The cell tower ping places the phone within half a mile of the Franklin County Courthouse at the time the message was sent. Whoever sent it was either in the building or very close to it." Marcus stood at Lorene's kitchen window, watching a gray dawn spread across Bryden Road like a stain. A garbage truck rumbled past. 2 children in winter coats walked toward the bus stop on the corner, their backpacks bouncing with each step. "What is your recommendation?" "Continue. The warning means the investigation is producing anxiety. Anxiety produces mistakes. But I am adding a layer. We are assigning a field agent to Columbus. Covert. You will not see them. They will not contact you, but they will be in the building when you are." "Understood." "And Marcus. The 7-day eviction window expires Monday. We need to file the federal emergency motion before then. I am sending the paperwork to Elena Rojas at the Columbus field office. She will file it under seal Friday morning. You will not be named. The motion will cite the investigation generally, requesting a temporary restraining order against all pending evictions in Croft's courtroom while the pattern or practice review proceeds. Will it work? It will work if the magistrate reads the statistical analysis. Black tenants losing at 89% versus 41% for white tenants. That is not a close question. But federal courts move at federal speed, which is to say, not fast enough for your aunt's timeline. So we might get the TRO after she has already been evicted. Della did not answer for a moment. The silence carried the weight of a career spent navigating the gap between legal theory and human consequence. "We are doing everything we can." "I know." He did not say what he was thinking, which was that everything the federal government could do still might not be enough to keep a 71-year-old woman in the apartment where she had raised him. That the machinery of justice, even when it was functioning as designed, operated on a timeline that treated urgency as an inconvenience. Thursday and Friday passed in a blur of documentation. Marcus spent 12 hours at the county recorder's office pulling property tax records, cross-referencing Ridgeline Holdings' portfolio with Jessup's inspection reports, mapping the data onto a spreadsheet that revealed, with mathematical clarity, the scope of the operation. 143 evictions in 3 years, all from properties owned by companies traceable to Marble Creek Capital, Sandra Tillman's entity, all preceded by inspection reports from Clark Jessup, all adjudicated in Harlan Croft's courtroom, all resulting in default judgments for the plaintiff. 143 families, displaced, scattered, erased from neighborhoods they had occupied for decades, their apartments renovated and relisted at rents that ensured the people who had been removed could never return. It was not complicated, it was not subtle. It was a business model built on the backs of people who could not afford to fight back, administered by a judge who had been appointed by the man whose family profited from every eviction he rubber-stamped. And it had been operating in plain sight for 3 years because the victims were poor, black, and invisible to every institution that should have been watching. Friday afternoon, Marcus received a call from Nadine Okafor. "Mr. Wade, I need to see you. Can you meet me at my office? It is on East Long Street, Suite 212. When? Now, if possible. I have information about your aunt's case that I do not want to discuss by phone. Marcus walked the 11 blocks to legal aid in 22 minutes, arriving at a building that looked like it had been converted from something else, a dentist's office maybe, or an insurance agency, and now housed 4 attorneys, 2 paralegals, and approximately 600 active cases representing people whose legal problems exceeded the office's capacity by a factor of 10. Nadine met him in a conference room that doubled as a storage space. Bankers' boxes lined the walls, stacked 4 high, each labeled with a case number and a year. A coffee maker on a side table produced a liquid that technically qualified as coffee, the way a municipal bench technically qualified as a courtroom. "Sit down, Mr. Wade." She gestured to a chair across the table from her. Then she opened a folder and slid a document toward him. It was a printout of an email. The sender's address was redacted. The recipient was Vera Stanton. The date was 3 days ago, Tuesday, the day before Marcus and Lorraine's hearing. The email read, "Supplemental report for CVG-04471 attached. File directly to Judge Croft. Do not enter into electronic system. Hard copy only." Marcus read the email twice. Then he looked at Nadine. "Where did you get this?" "A source inside the courthouse. Someone who has been uncomfortable for a long time and recently became uncomfortable enough to act. This is evidence of deliberate suppression. The inspection report was kept out of the electronic filing system on purpose." "Yes, which means the public cannot access it. Tenants cannot review it before their hearings. Defense attorneys, if there were any, cannot obtain it through normal discovery." "Yes. And the instruction came to Stanton directly, which means either Jessup or someone above him coordinated the suppression." Nadine leaned back in her chair. She was tired. The kind of tired that came not from lack of sleep, but from years of fighting a system that absorbed every blow she threw and kept standing. Her eyes were sharp, though, and they studied Marcus with an attention that made him conscious of his cover. "Mr. Wade, I have been practicing housing law in this county for 9 years. I have filed 3 complaints with the Judicial Conduct Board about Judge Croft. I have written to the State Attorney General. I have presented data to the county commissioners. Nothing has changed. Nothing has even been acknowledged." She paused, folded her hands. "And then you walked into that courtroom, and you cited rules, and you asked for transcripts, and you brought a moisture meter's calibration date into question during a building inspection. Those are not things tenants do, Mr. Wade. Those are things lawyers do." Marcus kept his expression neutral. The corduroy jacket, the worn shoes, the careful construction of a man who was earnest but outmatched, all of it balanced on the edge of Nadine Okafor's perception. "I have been reading," he said, "online. There are tenant rights organizations that publish—" "Mr. Wade." Her voice was gentle but precise. "I am not asking you to explain yourself. I am telling you that whoever you are, whatever your background is, I am glad you are here. And I want to help you." She slid a second document across the table. A printed spreadsheet. Columns of data, case numbers, tenant names, inspection dates, hearing dates, outcomes. 143 rows. The same data Marcus had been compiling from public records, but organized differently. Annotated with notes from legal aid case files, cross-referenced with tenant interviews, supplemented with information that was not publicly available. "I have been building this for 4 years, Nadine said. Every case I could document, every tenant I could interview, every pattern I could identify. And I have been waiting for 9 years for someone with the authority to do something about it." She looked at him, not at the jacket, not at the shoes, at him. "I do not know who you are, Mr. Wade, but I know you are not just a nephew fighting an eviction." Marcus said nothing for a long time. The coffee maker gurgled. Traffic passed on East Long Street. A phone rang in the outer office and was answered by someone whose voice carried the patient exhaustion of a person explaining legal procedures to a client who did not understand why understanding procedures should be necessary to keep their home. "Ms. Okafor," Marcus said finally, I cannot tell you who I am. Not yet. But I can tell you that your data, the 4 years of work in this folder, is not going to be wasted. She held his gaze for 3 seconds. Then she nodded once. I did not hear you say that. And we did not have this conversation. Agreed. She stood, gathered the folder, and placed it in his hands. Take it. I have copies. And Mr. Wade, whatever happens next, happen fast. Your aunt has 5 days. He walked back to Bryden Road, carrying the folder inside his jacket, against his chest, the way a man carries something that is both fragile and explosive. The November wind cut through the corduroy. He did not notice. If you think this is just about one apartment and one family, you have not been paying attention. What happens in the next 48 hours will crack this courthouse wide open. Saturday morning, 5 days before the eviction deadline. Marcus was sitting on Lorene's couch, reviewing Nadine's data on his secure laptop, when a knock came at the apartment door. Not a polite knock. 3 heavy strikes, spaced with the deliberate authority of someone who expected the door to open and did not intend to wait long if it did not. Lorene looked at Marcus. Marcus stood, closed the laptop, slid it beneath the couch cushion, and walked to the door. He looked through the peephole. Trent Bowling stood in the hallway, out of uniform. Civilian clothes, jeans, a dark jacket, work boots. No badge visible. No courthouse context to justify his presence on the second floor of an apartment building on Bryden Road at 9:15 on a Saturday morning. Marcus opened the door but did not step back. He filled the doorframe the way a person does when the space behind them contains something worth protecting. Deputy Bowling. Bowling's expression registered a flicker of something. Surprise, maybe, that Marcus remembered his name, or annoyance that the recognition eliminated the advantage of showing up unannounced. Mr. Wade, I am here in a personal capacity, not official business. I did not know courthouse security made personal visits to tenants facing eviction. Bowling's jaw tightened. The muscles in his neck, those thick, gym-built cords that Marcus had noted during their first encounter, shifted visibly beneath the skin. I know some people. People who are connected to the building management. They asked me to deliver a message. What message? The relocation offer expires Monday. 2 months assistance, clean reference. Your aunt signs, she moves, everybody moves on. No hard feelings. Ms. Dalton already communicated that offer. The deadline she gave was Friday. Friday was the lawyer's deadline. Monday is the real deadline. After Monday, the locks get changed. And I am being straight with you, Mr. Wade. That is going to happen whether you are in the apartment or not. If you are in the apartment when the marshals arrive, things get complicated. For you. The threat was no longer embedded. It was exposed, standing in the hallway in jeans and work boots, speaking words that would sound, on a recording, exactly like what they were. Intimidation of a tenant by a courthouse employee acting as an enforcer for the property management company that was evicting her. Marcus's phone was in his pocket. Recording. Deputy Bowling, I appreciate you coming by. I will discuss the offer with my aunt. Is there anything else? Bowling stepped forward, 1 step, close enough that Marcus could smell the coffee on his breath, the laundry detergent on his jacket, the particular aggression that some men carried in their bodies like a charge waiting for a ground. Yeah, one more thing. His voice dropped. Stop filing motions. Stop pulling records. Stop asking questions at the recorder's office. People notice, Mr. Wade. People with longer memories than you have. Is that a threat? It is advice. Free advice. Take it or do not. But remember, I came here on a Saturday to give it to you in person. That should tell you something about how serious the people I know are about making this problem go away. He turned and walked down the hallway. His boots made no sound on the carpet. The carpet was too worn to absorb anything or return anything, just a thin membrane between feet and concrete that had given up its original purpose years ago. Marcus closed the door, locked it, turned to face Lorene, who stood in the kitchen doorway with both hands pressed flat against the frame, as though holding herself in place. Who was that? Nobody important. Marcus, do not lie to me. I have known you since you were 9 years old. I know when you are lying. He walked to her, took her hands from the doorframe, held them. He works at the courthouse. He came to repeat the offer from the management company. I told him we would think about it. And the part where he told you to stop asking questions? She had heard. The walls in the apartment were thin enough for a woman in the kitchen to hear a conversation conducted in low voices at the front door. Marcus had not accounted for that. Another variable in a situation that was accumulating variables faster than he could track them. Aunt Lorraine, I need you to trust me. I do trust you. I have always trusted you. But trust does not mean I do not worry. She pulled her hands free, walked to the stove, and put the kettle on. The burner clicked 3 times before catching. That man had a look in his eyes, Marcus. I have seen that look before. Men who think they own the ground you stand on. Men who cannot understand why you will not just move when they tell you to move. I am not moving. Neither am I. She turned to face him, and in that moment, she looked less like a 71-year-old woman in a housecoat and more like the person who had raised a boy alone on 2 jobs and sheer refusal. But I need to know, is there something you are not telling me? The question sat between them like an object on the table. Heavy, real, requiring a response that was either honest or strategic, and Marcus was running out of room to be both. There are people working on this, he said. People with more resources than I have. People who care about what is happening in that courtroom. I cannot tell you more than that right now. But I need you to believe me when I say that what is happening to you is not going to happen to anyone else. Not after this. Lorraine studied his face the way she had always studied his face, reading the truth beneath the words, the way a woman reads weather by watching the sky rather than checking a forecast. All right, she said. I believe you. The kettle whistled. She made instant coffee. They sat at the table and drank it in a silence that was not empty but full. Full of things unsaid. Full of trust stretched thin but holding. Full of the particular intimacy of 2 people who loved each other enough to let the other keep their secrets. Sunday passed. Marcus attended to documentation, organizing evidence, preparing for what was coming. He walked the neighborhood, noting which buildings had inspection stickers, which had eviction notices, which had the quiet vacancy of properties that had already been emptied and were waiting for renovation. Monday morning, 2 days before the eviction deadline, Marcus arrived at the courthouse at 7:30 a.m. with a new motion. This one a formal objection to the shortened eviction timeline, citing Ohio Revised Code Section 1923.06 and requesting restoration of the original 10-day period. The motion was typed this time, printed at the public library on East Main Street, formatted with the careful imprecision of a self-taught litigant who had learned from templates but not from practice. The 4th-floor hallway was empty at 7:30. The clerk's window was closed. The courtroom doors were locked. Marcus sat on the bench, the same bench, always the same bench, and waited. At 7:45, Deputy Bowling arrived. On duty this time, uniform pressed, badge at the correct angle. He walked past Marcus without acknowledgement, took his position near the courtroom door, and began his morning routine of checking his phone and projecting the specific boredom of a man whose authority went unchallenged often enough to make the challenging of it feel like a personal offense. At 8:05, the clerk's window opened. Vera Stanton was behind the glass. She saw Marcus immediately. Her expression did not change, but her hand moved to the phone on her desk, the same gesture Marcus had observed the previous week, the reflexive communication of someone reporting a presence. Marcus approached the window. "Good morning, Ms. Stanton. I would like to file a motion in case 2024-CVG-04471. Vera accepted the document through the slot, read the first page, set it down. "This motion challenges the judge's order. You will need to request a hearing." "I am requesting a hearing. The next available date is December 9th. December 9th. 11 days after the eviction deadline. The hearing would be scheduled for a date on which Lorene would already have been removed from her apartment, her belongings placed on the curb or in storage, her 31 years of residence reduced to a line item in a county database. Is there an earlier date available? No. Can I request an emergency hearing? Emergency hearings are at the judge's discretion. I will submit the request. He will review it. Marcus knew what the review would look like. Croft would read the request, see the name Wade, and deny it with the same mechanical indifference he applied to every other motion from a black tenant who had the temerity to believe the system was supposed to work for them. "Thank you, Ms. Stanton." He turned from the window, walked toward the bench, and collided with someone who had been standing directly behind him, close enough to be deliberate, far enough to be deniable. Clark Jessup. Small frame, nervous eyes, clipboard in hand despite having no apparent business on the 4th floor. The collision was minor, shoulder to shoulder, the kind of contact that in most contexts would produce an "excuse me" and nothing more. But Jessup did not say "excuse me." He looked at Marcus with an expression that contained none of the nervous professionalism of their previous encounters. This was different. This was hard. "You need to watch where you are walking, Mr. Wade." The words were quiet, meant for Marcus's ears only, delivered with the tight precision of a man who had rehearsed them. "I am watching, Mr. Jessup, very carefully." Jessup held his gaze for 2 seconds. Then he adjusted his clipboard, stepped around Marcus, and walked toward the elevator. His shoes made soft sounds on the linoleum. His back was straight. His hands were steady. But Marcus noticed something he had not seen during the apartment inspection. On Jessup's left wrist, partially visible beneath his jacket sleeve, was a watch. Expensive, gold-toned. The kind of watch that a county building inspector making $58,000 a year would not typically wear. A small detail, the kind of detail that Marcus's training had conditioned him to notice and catalog without analysis. Analysis came later, when the pieces were assembled and the pattern emerged from the noise. He sat on the bench, wrote in his notebook, waited. At 9 a.m., the courtroom opened. Marcus did not enter. His motion would be processed through the clerk's office, and he had no hearing scheduled. But he stayed on the bench, listening through the open courtroom doors to the morning docket, counting cases, timing hearings, recording the steady rhythm of a system that processed human lives with the efficiency of an assembly line and the empathy of the machinery that ran it. At 10:15, the courtroom doors opened wider and people began filing out. The morning docket completed, another batch of futures decided, another set of families absorbed into the bureaucratic aftermath of losing their homes. Marcus watched them pass, a young couple holding hands and holding back tears, an older man walking with a cane and a vacancy in his eyes that suggested he had not yet processed what had happened, a woman carrying a folder of documents that had not been read and would not be read and existed now only as a record of effort that the system had declined to acknowledge. Among them, walking with the purposeful stride of someone who had business beyond the courtroom, was Priya Dalton. She saw Marcus on the bench, stopped. "Mr. Wade, have you considered our offer?" "I have." "And?" "I have a question. The relocation package. Who funds it?" Dalton's professional composure held, but her eyes narrowed by a fraction. "Ridgeline Holdings. It is part of their community relations program." "Does the program have a written policy? Something I could review?" "It is an internal company program. The terms are outlined in the offer letter I can provide." "And the waiver of appeal rights? Is that standard in relocation agreements, or specific to my aunt's case?" "It is standard practice. The company prefers clean transitions." "Clean transitions." Marcus repeated the phrase as though tasting it. "Ms. Dalton, my aunt has lived in that apartment for 31 years. The code violations that are being used to remove her were identified by an inspector whose calibration equipment is 14 months overdue. The supplemental report was filed directly with the judge and deliberately excluded from the electronic system. and the judge shortened the eviction timeline by 3 days without citing legal authority. He paused. Let the silence work. Does your client's community relations program address any of that? Dalton's composure cracked, not dramatically, not visibly to a casual observer, but enough for Marcus to see the recalculation happening behind her eyes. The same recalculation everyone in this courthouse performed when Marcus said things that did not fit the profile of the man they believed him to be. Mr. Wade, I am going to be direct. Continued resistance to this process is not going to change the outcome. It is going to make the outcome more painful for your aunt. I am offering a path that preserves her dignity and her rental history. That is more than most tenants in her position receive. Most tenants in her position do not have someone asking questions about calibration stickers and electronic filing suppression. The air between them solidified. Dalton held Marcus's gaze for a long moment. Then she clicked her pen, the same rhythmic, clock-like cadence he had noticed before, and returned it to her briefcase. The offer expires at 5 p.m. today. After that, we proceed under the court's order. She walked away, heels on linoleum, counting down. You are watching a system that has destroyed 143 families try to destroy one more. Subscribe now, because in the next few minutes, you are going to see what happens when the 144th family fights back with something this courthouse has never encountered. Tuesday, the day before the eviction. Marcus woke at 5 a.m. to a sound he did not immediately identify. Not the faucet. He had learned to sleep through that. Not the hallway light. Its hum was a constant. This was a new sound, rhythmic, metallic, coming from outside the apartment door. He moved to the peephole. The hallway was empty, but the sound continued, and now he placed it. Someone was changing the lock on the apartment across the hall. Unit 2A, the apartment that had been vacant for 3 weeks since its tenant, a woman named Denise Calloway, 64, retired, had been evicted through the same pipeline that was now targeting Lorene. Marcus opened his door. A man in gray coveralls knelt at the door of 2A, fitting a new deadbolt. Behind him, a second man carried paint cans up the stairs. "Excuse me, who authorized this work?" The man with the deadbolt looked up. "Management company. Renovation starts today." "The building has pending code violations. Is the renovation addressing those?" "I just install locks, man. Talk to the office." Marcus closed the door. The message was clear, even without words. The apartment next door was already being prepared for its next tenant. Lorene's apartment would be next. The machine did not stop. It did not pause. It consumed and moved forward with the indifference of something that had never been designed to see the people it processed. At 6:30 a.m., his secure phone rang. Della Vaughn. "Marcus, the TRO was filed Friday. Magistrate Judge Catherine Brewer has it. She reviewed the statistical analysis over the weekend. She wants a hearing." "When?" "Tomorrow morning, 10 a.m., Federal Courthouse, Room 3-C. Tomorrow morning is the eviction deadline." "I know. The hearing will address the TRO first. If Brewer grants it, the eviction is stayed. If she does not, Lorene loses her home while the federal government debates whether to do something about the judge who took it." "Marcus." Della's voice carried the controlled weight of someone delivering information she wished she did not have to deliver. "There is something else. I am coming to Columbus. Personally. I will be at the hearing tomorrow with 2 investigators from the Civil Rights Division." "You are coming?" "The investigation has reached the point where continued covert operation is no longer viable. Your cover is compromised. The anonymous text, Bowling's visit, Jessup's behavior. They know someone is asking questions. They do not know who you are, but they are close. If we wait longer, we risk losing the element of surprise that makes the reveal effective. So tomorrow, at the hearing, we disclose. I will present the sealed investigation order to Magistrate Brewer. You will be identified as a trial attorney with the DOJ Civil Rights Division. The investigation will become public." Marcus sat on the edge of Lorraine's couch. The apartment was still dark. Through the thin walls, he could hear the renovation crew next door, drilling, hammering, the sounds of a space being remade for someone new. And Lorraine? If the TRO is granted, she stays. The eviction is frozen. All pending evictions in Croft's courtroom are frozen. And if it is not? Then we file an emergency appeal to the Sixth Circuit. But Marcus, Catherine Brewer, has a 92% grant rate on civil rights TROs. The data is overwhelming. She will grant it. You said that about the system working 4 months ago. Della was quiet. Then, I will see you tomorrow. Federal Courthouse, 9:30. Bring your credentials. She hung up. Marcus sat in the darkness for a long time. Then he stood, walked to the kitchen, and started making coffee. The instant kind, made with water heated on the stove. Because the electric kettle still did not work, and the landlord still had not responded, and some things did not change no matter how many federal investigators were on their way. At 7 a.m., Lorraine emerged from her bedroom in her housecoat, moving with the slow deliberation of someone whose body had aged faster than her will. You are up early. Could not sleep. The drilling next door? Yes. She sat at the table. He poured her coffee. They sat together in the thin morning light, and Marcus made a decision that the investigation did not require, but that his conscience did. Aunt Lorraine, I need to tell you something, and I need you to listen to the whole thing before you respond. She set down her mug, looked at him with the steady attention of a woman who had been waiting for this conversation without knowing she was waiting. I am not just your nephew. I am your nephew. I will always be your nephew. But I am also something else. I am an attorney, a federal attorney. I work for the Department of Justice in the Civil Rights Division. I have been in Columbus for 4 months because the federal government is investigating Judge Croft and the eviction system in this courthouse. Lorraine did not move, did not blink. Her hands rested on the table, one on each side of her coffee mug, and her face held an expression Marcus could not read. Not shock, not anger, not relief, but something else. Something older. Something that came from a lifetime of being surprised by the world and learning to absorb surprise without letting it knock her over. Your eviction is real, he continued. The threat to your home is real. But the reason I am here, the reason I came to Columbus and moved into your apartment and wore these clothes and pretended to be someone I am not, is because what is happening to you is happening to hundreds of other families, and the only way to stop it was to be inside it, to experience it, to document it in a way that federal prosecutors could use. Lorraine picked up her mug, took a sip, set it down. You are a lawyer. Yes. For the federal government. Yes. And you have been living in my apartment for 4 months, wearing that jacket, letting that judge talk to you like you were nothing so you could catch him. So I could build a case. Yes. You sat in that courtroom and cried. Was that part of the case too? The question stopped him. He had prepared for anger, for hurt, for the specific betrayal of learning that someone you trusted had been performing a version of themselves while living under your roof. He had not prepared for this, the question that cut past the professional framework and landed squarely on the thing that mattered. No, the tears were real. Every time. When Croft mocked me, when he told me my tears cost 60 seconds, that was not acting, Aunt Lorraine. That was me watching a man destroy people's lives and not being able to stop him. Not yet. Not yet, she repeated. But now. Now. She was quiet for a long time. The faucet dripped. The renovation crew next door started a power drill that whined through the wall like a mechanical insect. Then Lorraine Wade did something Marcus did not expect. She laughed, not a small laugh, a full laugh, deep and genuine, the kind of laugh that comes from a place beyond worry, beyond fear, beyond the accumulated weight of 5 months of inspectors and courtrooms and eviction notices. Baby, she said, wiping her eyes, I knew something was wrong with you. No man reads that much about tenant rights unless he already knows them. You knew? I suspected. You talk different when you think I am not listening, more precise, like a man who measures his words with a ruler. She reached across the table and took his hand. "Why did you not tell me?" "Because telling you would have put you at risk. If Croft or Stanton or any of them suspected that you knew, they would have treated you differently. The documentation required authentic interactions." Authentic. She tested the word. "You mean they needed to treat me like garbage for real, so you could prove they treat people like garbage?" The accuracy of the statement was surgical. Marcus could not improve on it. "Yes." Lorene squeezed his hand. "Then I hope you got what you needed, because tomorrow I would like that judge to know exactly who he has been talking to." "He will." "Good." She stood, gathered her mug, walked to the kitchen sink. "Now, what should I wear?" Wednesday morning. Marcus dressed differently. Not the corduroy jacket, not the khaki pants, not the clean old shoes that had carried him through 4 months of performing a version of himself that was true in its grief, but false in its helplessness. He wore a charcoal suit, white shirt, dark tie, shoes that had been in the bottom of his duffel bag since the day he arrived, wrapped in a dry cleaning bag, waiting for this morning. He looked at himself in the bathroom mirror and saw, for the first time in 4 months, the man he actually was. In his breast pocket, folded in thirds, was his Department of Justice identification. Trial attorney, Civil Rights Division, bar number visible, photograph current. Lorene wore her dark blue dress again, the brooch at the collar. But she had added something, a pair of earrings Marcus had given her for her 65th birthday, small gold studs that caught the morning light as she turned her head. "You look like a lawyer," she said. "I am a lawyer." "You look like one today." They drove to the federal courthouse on East Broad Street in Marcus's Honda Civic. The building was everything the municipal courthouse was not: limestone facade, tall windows, the architectural language of a government that took itself seriously. Security at the entrance was thorough but professional. No theatrical ID checks, no shoulder touches, no questions about whether the black man approaching the metal detector belonged in the building. Marcus placed his phone and keys in the tray, walked through the detector. Clean. The guard handed back his belongings without commentary, without delay, without the small power plays that had defined every entrance to the municipal courthouse for 4 months. The contrast was not subtle, it was structural, the difference between a building that processed people and a building that served them. In the elevator, Lorene reached over and straightened his tie. The same gesture she had performed on the morning of his law school graduation, his first day at DOJ, his first oral argument before a federal panel. The gesture that said, "You are ready, whether or not you feel ready." "Aunt Lorene." "Yes?" "When we get in that room, the judge is going to say my name and my title. The people from the county courthouse, if any of them are there, they are going to hear it. They are going to know who I am, what I have been doing." "Good." "It might be difficult. They might react." She looked at him with an expression that carried 31 years of dripping faucets and peeling ceilings and inspectors with clipboards and judges who did not listen. "Marcus, I watched that man tell you your tears cost 60 seconds each. Difficult is what I have been living in. Whatever happens in that room is going to be an improvement." They arrived at Courtroom 3C at 9:25 a.m. The room was larger than Croft's courtroom, with higher ceilings and better light. A portrait of a former Chief Justice hung on the wall behind the bench. The seal of the United States District Court for the Southern District of Ohio was mounted above the door. Della Vaughn was already there. She stood near the petitioner's table, reviewing documents with 2 people Marcus recognized from the DOJ's Columbus field office. Field investigators whose names he knew, but whose faces he was seeing for the first time outside of video conferences. Della looked up when Marcus entered. Her expression softened for a fraction of a second, the brief, unguarded acknowledgement of a supervisor seeing an agent come in from the cold, before resettling into its professional default. "Marcus, you look different." "I feel different." She nodded, glanced at Lorene. "Ms. Wade, thank you for being here." "Thank you for caring enough to send him," Lorene said. And the simplicity of it, the gratitude expressed without drama, without fanfare, without any awareness that it would make 3 federal employees blink, landed in the room like something warm. At 9:45, the door at the back of the courtroom opened, and 3 people entered whom Marcus had not expected. The first was Priya Dalton, representing Ridgeline Holdings, accompanied by a second attorney. Marcus did not recognize, older, gray-suited, carrying a briefcase that suggested a downtown firm and an hourly rate that started with a comma. Ridgeline had upgraded its legal representation overnight, which meant someone had told them what was coming. The second was a man Marcus recognized from photographs in the investigation file. Commissioner Ray Tillman, 67, white hair. The calculated tan of a man who played golf in seasons when golf should not be played. He sat in the gallery's back row, alone, his presence technically that of a private citizen observing a public hearing, but functionally that of the man whose financial empire was about to be named in a federal complaint. The third, and this was the surprise, was Harlan Croft. Not in his judicial robes, not sitting on a bench. Sitting in the gallery, 3 rows behind Tillman, wearing a sport coat and an expression that suggested he had been told to be here, but not told why. Marcus looked at Della. She gave a barely perceptible nod. She had arranged for notifications to be sent. She wanted them in the room. At 10 a.m., Magistrate Judge Catherine Brewer entered. Everyone rose. Brewer was 59, black, appointed to the federal bench by the previous administration, with a reputation for meticulous procedure and 0 patience for lawyers who confused eloquence with substance. Her reading glasses were already on. She had been reviewing the file. This is the matter of the United States of America versus Franklin County Municipal Court Housing Division, emergency petition for temporary restraining order. The United States is represented by... She looked at the petitioner's table. Please state your appearances. Della stood. Della Vaughn, Section Chief, Housing and Civil Enforcement Section, Civil Rights Division, United States Department of Justice. With me is trial attorney Marcus Wade, also of the Civil Rights Division. The name hit the courtroom like a dropped gavel. In the gallery, Croft's head turned. Slowly. His eyes found Marcus. The man in the charcoal suit, the man who had stood at his podium in a corduroy jacket and cried. The man he had mocked and dismissed and processed with the mechanical indifference of a system that assumed every black face at the defendant's table was interchangeable. Recognition came in stages. First the face, the same face, older than Croft had registered, sharper now without the softening effect of apparent helplessness. Then the name, Wade, the nephew, the pro se litigant who cited wrong rules and brought handwritten motions and cried when his aunt's hearing lasted less time than a commercial break. Then the title, Trial Attorney, Department of Justice, the 3 words that transformed a man Croft had dismissed as insignificant into the instrument of his professional destruction. Croft's face drained of color. Not gradually. All at once, the way a screen goes dark when the power is cut. His hands, which had been resting on his thighs, gripped the edge of the gallery bench with enough force to whiten his knuckles. 3 rows ahead of him, Commissioner Tillman's phone buzzed. He looked at the screen. His jaw tightened. He did not answer. Priya Dalton and her senior co-counsel exchanged a glance that communicated, in the silent language of attorneys confronting an unexpected federal action, the specific realization that their client's exposure had just expanded from a housing dispute to a civil rights investigation. Magistrate Brewer continued without acknowledging the gallery's distress. The respondent? Dalton's co-counsel stood. Gordon Whitfield, Whitfield and Associates, appearing on behalf of Ridgeline Holdings, LLC. We received notice of this hearing 12 hours ago and have not had adequate time to prepare a response. We request a continuance of... Denied. Brewer did not look up from the file. This is an emergency petition. The eviction at issue is scheduled for execution tomorrow. A continuance would moot the petition. Proceed, Ms. Vaughn. Della stood with the composed authority of someone who had argued in rooms like this for 30 years and had learned that the most powerful presentations were the quietest. Your Honor, The United States brings this emergency petition based on a 4-month investigation into patterns and practices of racial discrimination in the Franklin County Municipal Court Housing Division. The investigation, conducted under 42 U.S.C. Section 3614, the Fair Housing Act's pattern or practice provision, has documented systemic disparities in how black tenants are treated compared to white tenants in eviction proceedings. She opened a folder. Precise. Methodical. Each document positioned for maximum impact with minimum theatrics. Over the past 3 years, black tenants in Judge Harlan Croft's courtroom have received an average hearing time of 3.2 minutes compared to 8.7 minutes for white tenants. The default judgment rate for black tenants is 89% compared to 41% for white tenants. 143 evictions during this period involved properties owned by entities traceable to a single beneficial owner whose financial relationship with the appointing county commissioner creates an undisclosed conflict of interest. She paused. Let the numbers land. Additionally, the investigation has documented coordination between the county building inspector, the court clerk, and the property management company to fabricate or inflate code violations, suppress inspection reports from public access, and manipulate docket scheduling to disadvantage black tenants. Magistrate Brewer's pen moved across her notepad. What specific evidence supports these allegations? Your Honor, trial attorney Wade was embedded in the Franklin County Housing Court system for 4 months as a litigant in an active eviction case. He personally experienced and documented the discriminatory practices described in the petition. With the court's permission, I would like Mr. Wade to summarize his first-hand observations. Proceed. Marcus stood. The courtroom was quiet in the particular way that rooms become quiet when every person present understands that what happens next will be referenced in legal filings and news reports and professional consequences for years to come. He spoke for 11 minutes. No notes. No dramatics. Just a chronological account of what he had witnessed. Tanya Myers's 94-second hearing, Gerald Hoskins's denied continuance, Vera Stanton's lost filings and sticky note annotations, Deputy Bowling's selective enforcement of non-existent seating policies, Clark Jessup's uncalibrated moisture meter and fabricated code violations, the supplemental inspection report filed directly to the judge and deliberately excluded from the electronic system, the anonymous threatening text, Bowling's off-duty visit to Lorene's apartment, Priya Dalton's relocation offer conditioned on waiver of appeal rights, each detail cited with the precision of a man who had spent 4 months counting stairs and timing hearings and recording conversations, filing them into a structure that transformed individual acts of bias into a documented pattern of institutional discrimination. When he finished, the courtroom was silent. Magistrate Brewer looked at the gallery. At Croft, whose color had not returned. At Tillman, whose phone was buzzing continuously and being continuously ignored. At Dalton's co-counsel, who was writing notes with the focused urgency of someone composing a damage assessment. Mr. Whitfield, do you wish to respond? Whitfield stood slowly. He was experienced enough to know that the wrong words in this moment would create more liability than silence, and strategic enough to choose his words with the precision of a surgeon selecting instruments. Your Honor, Ridgeline Holdings categorically denies any participation in discriminatory practices. The eviction proceedings at issue were conducted in accordance with Ohio law and based on documented code violations identified by a licensed county inspector. My client has no knowledge of or involvement in any coordination between court personnel and the building inspection office. Does your client deny the beneficial ownership connection to Commissioner Tillman? Whitfield hesitated. 1 second. 2. We are not in a position to address ownership questions at this time. That is not a denial, Counselor. It is a statement that the issue requires further review before we can respond accurately. Brewer nodded once. Then she spoke, and the words carried the weight of a federal court exercising its authority over a system that had operated without oversight for 2 decades. The petition for temporary restraining order is granted. All pending eviction proceedings in the Franklin County Municipal Court Housing Division, presided over by Judge Harlan Croft, are hereby stayed pending completion of the Department of Justice's pattern or practice investigation. This stay applies to all cases currently on the docket and any new filings until further order of this court." She looked directly at the gallery, at Croft. "Additionally, this court is referring the matters raised in this petition to the United States Attorney for the Southern District of Ohio for determination of whether criminal charges are warranted under 18 U.S.C. Section 242, deprivation of rights under color of law, and 18 U.S.C. Section 371, conspiracy to defraud the United States. The investigation should include, but not be limited to, the conduct of Judge Harlan Croft, Court Clerk Vera Stanton, Building Inspector Clark Jessup, and any county officials with undisclosed financial interests in the properties at issue." She set down her pen. "Court is adjourned." The gavel fell once. The sound was different here. Cleaner, sharper, carrying a finality that Croft's gavel had never possessed, because Croft's gavel had been wielded in service of a system designed to produce outcomes rather than justice. This gavel produced justice, or at least the beginning of it. The courtroom erupted, not in chaos, but in the controlled release of tension that happens when a system that has been holding its breath for years is finally allowed to exhale. Dalton's co-counsel was on his phone immediately, speaking in the rapid, clipped tones of a lawyer communicating very bad news to a client who was about to become significantly more expensive. Tillman stood, buttoned his jacket, and walked toward the exit with the measured pace of a man who understood that running would look like guilt but wanted very much to run. Croft sat motionless. His hands had not moved from the bench edge. His eyes had not moved from Marcus. And on his face, visible now to everyone in the room, documented by the courtroom security cameras, witnessed by 2 federal investigators, and a magistrate judge, and the woman he had mocked for crying, was the specific expression of a man who had just realized that the person he had treated as nothing was, in fact, everything. Marcus did not look at Croft. He looked at Lorene. She sat in the gallery's front row, her hands folded in her lap, her brooch catching the courtroom light, and on her face was an expression he would remember for the rest of his life. Not triumph, not vindication, not the satisfaction of watching powerful people face consequences they had spent decades avoiding. Peace. The quiet, exhausted, hard-won peace of a woman who had just been told she could stay in her home. "Aunt Lorene," Marcus sat down beside her. "You are not going anywhere." She took his hand, squeezed it, did not speak. The tears came, hers and his, and this time there was no judge to mock them, no gavel to measure their cost, no courtroom full of strangers being taught that grief was a weakness to be punished rather than a truth to be witnessed. In the hallway outside courtroom 3C, the controlled energy of the hearing broke apart into fragments. Attorneys reaching for phones, investigators exchanging quiet words, the particular shuffle of people processing the sudden rearrangement of a world they had assumed was stable. Marcus walked Lorene to a bench near the elevator bank, away from the cluster of officials and cameras. She sat with her hands folded, the gold studs in her ears catching the overhead light, her breathing steady in a way that suggested the steadiness was a choice rather than a condition. "I need to speak with my supervisor for a few minutes. Will you be all right here?" "Baby, I have been all right for 71 years. I can manage a hallway." He was turning back toward the courtroom when a hand closed around his arm. Not gently. The grip was tight, the fingers digging into the fabric of his suit jacket with the desperate force of a man who had lost control of everything except his ability to grab. "You stood in my courtroom." Harlan Croft's voice was a ragged thing, stripped of the judicial authority that had sustained it for 22 years, reduced to the raw frequency of a man confronting the collapse of his own assumptions. "You stood there, and you let me. Judge Croft." Marcus did not pull his arm free, did not raise his voice, did not step back. He looked at Croft with the same steady gaze he had maintained at the podium, at the clerk's window, on the bench where Bowling had laid a hand on his shoulder. "I suggest you release my arm and contact your attorney. You made a fool of me. No, Judge, You made a fool of yourself. I just recorded it. Croft's hand opened. His fingers left marks on the suit fabric. 4 shallow indentations that would smooth out within an hour, but that Marcus noted and would include in his report. Physical contact with a federal officer by a subject of investigation. One more item on a list that was already long enough to end a career. A federal investigator appeared at Marcus's shoulder. A woman named Torres, mid-30s, whose badge was visible on her belt, and whose positioning between Marcus and Croft was not accidental. Judge Croft, this is Agent Torres. Any further communication regarding the investigation should be directed through your legal counsel. Croft looked at Torres, at Marcus, at the hallway full of people who had just witnessed a municipal judge grab a federal attorney's arm outside a courtroom where his 22-year tenure had just been placed under investigation. Then he turned and walked toward the exit, his sport coat hanging on shoulders that seemed, in the span of 30 seconds, to have lost the architecture that had held them upright for decades. Tillman was already gone. His car, a silver Lexus that Marcus recognized from the campaign finance disclosures, was pulling out of the parking structure before Croft reached the elevator. Back near the courtroom, Nadine Okafor stood at the periphery of the legal team's cluster, holding her folder, the same folder she had given Marcus, the 4 years of data that had supplemented the federal investigation with ground-level testimony the DOJ could not have gathered on its own. Della approached her, extended her hand. Ms. Okafor, I want you to know that your data was instrumental in building this case. The complaint letters you sent to the Judicial Conduct Board may not have produced action at the state level, but they were among the first documents that triggered our investigation. Nadine shook Della's hand. Her expression was complex, relief and exhaustion and the particular frustration of someone who had been saying the same thing for 9 years and was only now being heard because someone with a federal badge had said it louder. I sent those letters to everyone I could think of, Nadine said. The board, the AG, the county commissioners. I thought no one was reading them. We read them, everyone. It took 18 months. Yes, it took too long. I will not pretend otherwise. Nadine nodded. She did not say what she could have said. That 18 months meant 18 months of families being evicted while the federal government reviewed data and assigned investigators and built a case with the methodical slowness of an institution that could afford to be patient because the people it was trying to protect could not. She did not say it because saying it would not change the timeline. Nothing could change the timeline. The families were already gone. But the ones who came next, the ones whose evictions were now stayed, whose cases would be reviewed, whose homes would remain theirs while the investigation ground forward. Those families existed because Nadine Okafor had spent 9 years writing letters that she believed no one was reading. Someone had been reading. And Delavon held a brief press statement. 3 cameras, 2 print journalists. 3 cameras, 2 print journalists. A radio reporter with a digital recorder held at arm's length. The Department of Justice has opened a pattern or practice investigation into the Franklin County Municipal Court Housing Division. We have obtained a temporary restraining order staying all pending evictions in Judge Croft's courtroom. The investigation will examine allegations of racial discrimination in hearing procedures, docket scheduling, code violation inspections, and conflicts of interest involving county officials. A reporter raised her hand. Is Judge Croft facing criminal charges? The matter has been referred to the United States Attorney for evaluation. I cannot comment on potential criminal proceedings. What about Commissioner Tillman? All aspects of the investigation are ongoing. We will provide updates as appropriate. How many families are affected? Based on our preliminary analysis, at least 143 eviction cases over the past 3 years may have been impacted by the practices under investigation. We are establishing a hotline for affected tenants to contact the Civil Rights Division directly. The press conference lasted 4 minutes, brief, factual, the kind of statement that generates follow-up coverage not because of what was said, but because of what was implied. Inside the courthouse, the machinery of consequence had already begun to turn. By Thursday, 2 days after the hearing, The Franklin County Judicial Conduct Board had opened a formal investigation into Harlan Croft. The investigation would take 6 to 18 months, during which Croft would remain on the bench, but would be barred from hearing housing cases. His 22-year tenure in Courtroom 4B was effectively over, though the official end would arrive later, carried on the slow tide of administrative process. Vera Stanton was placed on administrative leave by the court administrator's office. Her personnel file was opened for review. The yellow sticky notes, Pro C, difficult, cited rules, watch, were preserved as evidence. The lost filings, the suppressed reports, the deliberately scheduled docket that clustered black tenants into the first 90 minutes of the morning session, all of it was being cataloged by investigators who would spend months untangling a system that had taken years to construct. On the morning Stanton was escorted from the courthouse, Marcus was in the building filing supplemental documents. He saw her in the lobby, carrying a cardboard box of personal items, her court ID badge surrendered, her expression caught between fury and the dawning recognition that the world she had controlled from behind a clerk's window no longer answered to her. She saw him, stopped. The box shifted in her hands. You, the word carried venom refined by decades of institutional authority, suddenly stripped away. You came to my window. You stood there with your handwritten motion and your questions about formatting requirements. And the whole time I was documenting a system that lost Tanya Myers's filing, Marcus said. A system that scheduled black tenants into the first 90 minutes so the judge could dispose of them before his coffee got cold. A system you administered, Ms. Stanton, every sticky note, every suppressed report, every lost continuance motion. Stanton's mouth opened, closed. The box trembled in her hands. Then she walked past him, through the glass doors, into the November air, and Marcus did not watch her leave, because watching would have felt like victory, and what had happened in Courtroom 4B deserved something more complicated than victory. Clark Jessup resigned from the building inspection office on Friday morning, 3 days after the hearing. His resignation letter was 2 sentences long and cited personal reasons. The Franklin County Prosecutor's Office opened a separate investigation into his inspection reports, focusing on the 187 reports targeting majority black census tracts. The investigation would determine whether the fabricated violations constituted official misconduct under Ohio Revised Code Section 2921-44, a determination that would take months and might or might not produce charges depending on the prosecutor's assessment of available evidence and political appetite for prosecuting a county employee. Commissioner Tillman issued a statement through his office denying any knowledge of discriminatory practices in the housing court. His wife Sandra's role as managing member of Marble Creek Capital, LLC, was described as a private business matter unrelated to county governance. The statement did not address the financial connection between Marble Creek Ridgeline Holdings and the eviction pipeline that had enriched the Tillman family while displacing black families from their homes. The statement convinced no one. A county ethics investigation was opened the following week. Tillman hired 2 attorneys and a crisis communications firm. The investigation would take a year, maybe longer. The outcome would depend on factors that had nothing to do with truth and everything to do with the political calculations of officials whose careers depended on managing scandal rather than preventing it. Priya Dalton withdrew from all Ridgeline Holdings cases. Her firm issued a brief statement. We are cooperating fully with the federal investigation and have no further comment at this time. Dalton herself was not named as a subject of the investigation, but her role in communicating the coercive relocation offer, appeal waiver in exchange for housing assistance, was documented in the DOJ file and would be reviewed by the State Bar's Ethics Committee. Trent Bowling was reassigned from courthouse security to an administrative position in the county sheriff's office. His off-duty visit to Lorene Wade's apartment was included in the DOJ's evidence file. His union filed a grievance contesting the reassignment. The grievance would be heard, deliberated, and ultimately denied. But the process would take 4 months, during which Bowling would continue to receive his full salary while sitting at a desk reviewing paperwork instead of patrolling courthouse hallways. These were the outcomes, not dramatic, not cinematic, not the clean, satisfying resolution of a system that punishes the guilty and rewards the righteous. These were the messy, incomplete, frustratingly incremental outcomes of a legal system that moved at the speed of procedure and measured justice in administrative actions rather than moral reckonings. Deputy Bowling filed a formal grievance through his union, claiming the reassignment was retaliatory. His union representative, a man named Carl Hennings, who had successfully defended officers against misconduct charges 14 times in the past 6 years, issued a statement calling the DOJ investigation an unprecedented federal overreach into local judicial operations. The statement was covered by the local news. 3 people quoted in the story agreed with Hennings. 11 disagreed. The comments section ran to 400 entries before the newspaper disabled it. The anonymous text message remained unattributed. The prepaid phone was never recovered. The investigation flagged it as an open item, one of the threads that would persist long after the main case was resolved, a reminder that systems of institutional corruption communicated through channels that formal investigations could not always reach. 143 families had been displaced. Some would be found, some would be contacted by the DOJ hotline, some would receive restitution through a process that had not yet been designed. Some would never be found, scattered by the eviction pipeline into shelters, relatives' homes, other cities, other lives that bore the permanent scar of having been removed from a place they belonged. The system that had done this to them was being examined, not dismantled, examined. The examination would produce reports, recommendations, consent decrees, oversight mechanisms. It would produce change, real, measurable, documentable change. But the change would arrive slowly, resisted at every step by the institutional antibodies that every system produces when it is threatened with accountability. And Lorene Wade would stay in her apartment on Bryden Road. The eviction was vacated. The code violations were under review. The faucet still dripped, the hallway light still flickered, and the landlord still did not respond to maintenance requests. But the court order that had hung over her door, the piece of paper that had tried to reduce 31 years of life to a 10-day countdown, was gone. On a Thursday evening, 2 weeks after the hearing, Marcus sat at Lorene's kitchen table for the last time. His duffel bag was packed. The charcoal suit was hanging on the back of the bedroom door, waiting to be worn back to Washington where it belonged. Lorene made dinner. Not instant coffee and not reheated greens, but a full meal. Fried chicken, collard greens, cornbread, sweet potatoes, the kind of meal she made when something worth celebrating had happened, and she wanted the celebration to taste like home. They ate in the warm light of the kitchen, with the faucet dripping its 3-second rhythm, and the hallway humming its fluorescent accompaniment, and the sounds of the building settling around them like the breathing of something old and tired and still standing. "You are going back," she said, "tomorrow. To your office, your real life." This was real too, Aunt Lorene, every minute. She reached across the table and straightened his collar. A gesture so familiar, so deeply embedded in the muscle memory of a woman who had been straightening a boy's collar since he was 9 years old, that it required no thought. Just love, expressed through the small habitual maintenance of someone she had raised and released and was now releasing again. "You come back and visit, not as a lawyer, not as an investigator, as my nephew." "I will. And fix that faucet before you leave." He laughed. "I will try." After dinner, Marcus took his secure laptop to the couch and logged into the case management system for the last time from this location. He uploaded his final field report, 47 pages of observations, evidence logs, and recommendations, and closed the file. Then he opened his email. One new message from Nadine Okafor. "Mr. Wade, or should I say Attorney Wade, I want you to know that the data I gave you has been supplemented by 37 additional tenant complaints that came in through the DOJ hotline this week. 37 families, I have been doing this work for 9 years and I have never seen this many people willing to come forward. Whatever you did in that courtroom, it mattered. Thank you. Nadine. He read the email twice, closed the laptop. The apartment was quiet. Lorene had gone to bed. The drilling next door had stopped. The renovation of Unit 2A had been paused by the TRO, which froze all property actions connected to the investigation. The hallway was still. The building, for the first time in months, felt like a place where people could stay. Marcus walked to the kitchen, opened the cabinet beneath the sink, found a wrench that Lorene had kept in the same drawer for 20 years. He tightened the faucet fitting, 1 turn, then half a turn more, and the dripping stopped. The silence was startling. 3-second intervals of nothing, where before there had been the steady percussion of water on steel. The kitchen felt different without it. Emptier, but also, somehow, more complete. He put the wrench back, washed his hands, dried them on the dish towel that hung from the oven handle. The same towel, same handle, same gesture he had performed thousands of times as a boy doing dishes after dinner, while Lorene worked the evening shift at the Holiday Inn. Then he noticed something on the counter that had not been there at dinner. A small envelope, white, unsealed, with no return address. Lorene's name was typed on the front. Not handwritten, typed, the kind of impersonal precision that suggested a form letter or an automated mailing. He opened it. Inside was a single sheet of paper, a property tax reassessment notice for 1847 Bryden Road, Unit 2-B. The assessed value of the apartment had been increased by 340%, from $18,000 to $79,200. The increase would raise Lorene's annual property tax obligation from $412 to $1,714. The effective date was retroactive to July 1st, 3 months earlier. The notice was signed by the Franklin County Auditor's Office. But the issuing subdivision listed at the bottom of the page, Reassessment Division Section 12, did not appear in any county organizational chart Marcus had reviewed during his 4 months of investigation. Section 12 did not exist. Marcus stood in the kitchen, holding the paper. The faucet was silent. The hallway was dark. And somewhere in the machinery of Franklin County government, a new mechanism had engaged, one that the investigation had not mapped, that the TRO did not cover, that existed in the space between the system Marcus had documented and the system that continued to operate in the shadows he had not yet reached. He photographed the notice, uploaded it, sent a message to Della Vaughn. New vector, property tax reassessment, retroactive, issuing division does not exist, pipeline continues. The response came in 11 seconds. Noted. Expanding investigation. Get some sleep, Marcus. You have earned it. He put down his phone, looked around the kitchen, the table where he had eaten 10,000 meals, the chair with its cardboard shim, the window that looked out onto Bryden Road, where the streetlights burned amber and the sidewalks cracked and the neighborhood held on with the stubborn patience of a place that had been waiting a long time for someone to notice it was still here. He had noticed. He had documented. He had stood in a courtroom and said his name and watched a judge's face drain of color. But the notice on the counter said what the notice on the counter always says, in every investigation Marcus had ever worked, in every system he had ever tried to hold accountable. The machine had more arms than any single case could reach. Cut one, and another extended. Block one pipeline, and another opened, quieter, deeper, harder to find. The fight was not over. It was never over. Marcus Wade turned off the kitchen light, walked to the couch, and lay down in the dark apartment where he had been a nephew and an investigator, and a man in a worn jacket who cried in a courtroom, because crying was the most honest thing a person could do when the world was operating exactly as designed, which was to say, against the people it was supposed to protect. Tomorrow, he would drive back to Washington. He would file his report. He would begin the next phase of an investigation that would take years to complete and might never fully succeed. But tonight, the faucet was fixed, and Lorene Wade was sleeping in her own bed, in her own apartment, in the home she had kept for 31 years. That was enough. For now, that was enough.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.